assure you that all the matters are.
I don't make a mention. My matter is about my loss view on bail matter. Lordship, it will come on.
You would go to the same court.
Lordship, due to assignment changes.
That's right, but the interim bail was granted by that court.
Whole difficulty, your Lordship, newly couple married.
That's the best thing. You will come out and will start fighting.
How say how kind only humanitarian ground, your Lordship,
I know, take it. Huh? But it was given by the coordinate bench, so it may not be proper for me.
Lordship, Lord, in the
You call for the file. Let me see. Huh? Wait. Huh? Call for the file. If it is possible, I'll hear it. Otherwise, I'll relegate.
No, marriage and all exist.
I understand it. I understand.
Only on humanitarian ground.
Get the file. Let us see.
Pardon to mention under offense under section of 498A 304B.
See, if bail matter, please don't mention. Don't waste time. I will not entertain it. Bail matters will come serially. No question of jumping. No, whatever. What can I do? If I start entertaining you, then there are many other.
I have
Please hold on. Please hold on.
I have filed an interim bill. The father serious surgery, heart surgery. I have filed an interim bill. That will be taken on Tuesday.
Not you don't decide the date, but give it. We'll see.
Pardon to make a mention.
You give the memos, but I am making it again clear that no jumping. It should be serious. Mr. Kotokia is also having similar.
From the side of defense.
You will not be entertained. You have been this side and opposing everything. Now you want something. Yes, what do you want?
With due apology, of course, I have now concern about the mood of the court. So this is a bail application. Of course, for avoidment to suicide, a person is banned for 6 months.
See, the problem is if preference is given to one bail application, the other people are deprived. So what I am trying to tell you is, let us follow the system.
Yes.
So I will try to make sure that all the bail application within 10-15 days all are heard. Please give your memo. We'll see.
Pardon to make
And you are the best person to know from that side.
My lord, pardon to make a mention, my lord, my also is bail application, but the petitioner have 2 minor child. They don't have any.
Please, in a bail application, every case has some urgency or the other. My lord, please don't mention it. I have told you it will come in serious.
2 minor child.
Maybe.
Plus another matter in one interim bail application. There your lordship was directed to get it listed on 20th August. But by mistake, lordship has been mentioned as 20th September. Because she's suffering from a terminal disease. I mean, petitioner's mother. Suffering from cancer.
Take it up. Huh? Give it.
Pardon to mention, my lord, CRL number 776 of 2024, fresh admission.
Fresh admission. Great. Will come. Fresh admissions are coming. No problem.
Yes, my lord.
Every day I am taking a couple of those matters also.
I have another prayer, my lord. Item number 64, my lord. I have filed a IA, interim application, my lord. Your lordship, it is not come to the board, my lord, today. I have filed today, my lord, tomorrow morning, my lord. Your lordship is taken up to...
when it comes, you just intimate me so that I will do it.
My lord.
Okay, no problem. Yes, madam.
Lords, may I mention, my lords?
Can I make
Lords,
a
on the virtual mode, my lords, mention. My lords, item
1 minute, Mr. 1 minute, see. Yes.
Lordship, item 68 and 73 may kindly be adjourned. Senior Advocate Dharnidhar Naik is unwell.
Okay, yes. Adjourn.
68 and 73.
68 and 73. Simply adjourn, huh?
Obliged, Lordship.
Unveil, take. Yes, online mentioning. Yes,
May I make a mention,
Mr.
Lord?
Samantha, yes. Yes, sir. Yes, sir.
There is an item in the weekly list 117. I had made a mention on Tuesday. Can it be taken up someday next week, my lords, at 2 o'clock? A small matter.
And any day next week, get ready. After 3 o'clock, I'll take it up.
My lords. And another prayer
Because
for supplementary list. In today's supplementary list, item 70,
Yes.
the trial court has fixed the date to the matter today also. So can it be taken up as the last item if it doesn't reach?
No, I'll take up all the matters. Don't worry.
Obliged.
If it doesn't reach, then please remind me at 2 o'clock. Then
Obliged.
I'll take it.
Obliged.
No problem. Okay. Yes.
Wait, please, Abhish.
May I beg your pardon, sir? I want to mention a dual FPL number. Last
What do you
last
want,
date
sir?
was
You want listing, huh?
one thing for listing, sir.
Listing, it will be listed, no problem. You give the memo through your instructing counsel here, it will be taken up. Okay,
Sir. Item 1.
thank you.
Item 1, Lordship.
And your senior is there. Yes,
Item 1. Here, Lordship.
item 1.
Lordship.
Yes.
It's a case, Lordship, both parties have settled, and it's a case under 376 and POCSO. Parties are measured, they are before Lordship only. And they also file a joint affidavit on that regard. That is there.
What is, they married or what? Huh?
They
married.
compromise the issue, Your Lordship. I am for the victim.
Compromise is not.
They will marry. The family already settled. The girl is walking outside
Are you
at
covered by,
Bangalore.
are you covered by Rosalind?
Rosalind Raut, my lord.
This case not coming under the Rosaline, but
Right.
recently 2 days before, my lord, the Honorable Appeals Court quashed one matter. That case, my lord, POCSO Act there, my lord. The trial court convicted the accused. Thereafter, Calcutta High Court, my lord, acquitted accused and take some views given by against the victim, my lord. Thereafter, the matter so much, my lord, listed Honorable Appeals Court, my lord. Yes, 2 days before, my lord, Appeals Court quashed my lord, upheld the conviction and stated that any circumstances the POCSO cannot be quashed, my lord. Here, my lord, POCSO is there.
So me.
My lord, I'll give that.
That is there, then difficult. Let us see. Because of see the now the mood of the country you have seen.
That's
what is
true.
happening.
But in this case, Lordship, the victim was also mentioned by the time of the occurrence and the allegation also. Now she is 22 years old. And because of the intervention of the village entry and the public, they've settled the dispute. They are now very peaceful in their life. And
Are
they
they, are they married or going to?
They are going to. After the settlement only, they can go for marriage. Because the
No,
tribal
she is not
tribe.
married. She is not
Yes, she
married.
is now.
And why they are not married?
Because there is a dispute with pending. So for some emotional issues are there.
Or let them
They-
marry then and
they-
come.
Exactly.
Your
Marry
lordship,
then come.
Then, my lord, Rosalind will come.
now, my lord.
If you
the-
marry, then Rosalind will step in. Otherwise, you are not. I will record it
Right.
and adjourn it. Let them marry and come. We'll see.
Protection may kindly be given. Because
Why?
the petitioner number 1 yet not arrested in this
Absconding.
absconding.
Although charge sheet has been submitted, that is part of the record. But somehow he has not been arrested. He is shown as an absconder. There are 3 accused persons. So prime accused who was having the relationship.
Let him surrender, and I will record all these things.
Grateful.
And obviously, he
They will not custody.
Yes,
will-
please, how to sort it out?
If-
The problem is absconding. Second is they are going to marry his measure because she is because there is no protection. He can't marry also.
Yes, the apprehension will be
If
there.
you surrender before the court, my lord, then you also direct him to approve the trial court, my lord. One court, a single court, my lord, the special court, my lord. Therefore, the victim file affidavit, they will be released on bail, my lord. The court will, my lord.
The court will not
Therefore,
consider
purpose
in
is solved, my lord.
maximum circumstances, your lordship.
What I'll do is I'll pass a no course action and let them do.
My lord.
If they marry, then we'll see.
Yes, that will also suffice.
Right.
Right, sir.
At the instance of the opposite party number 2, the FIR number so and so came to be registered. Who is the opposite party number 2? The girl herself.
Lordship.
My lord.
The lady.
The allegation against the petitioner. Where have you mentioned allegations?
Allegation, my lord, in the
Para?
compromise.
2. Para
My
2.
lord.
Para. Investigation is complete. No.
Not completed.
Investigation.
Preliminary charge sheet submitted.
Investigation for the present case is still going on. However, preliminary charge sheet has been filed. When the matter stood thus, the opposite party number 2 has entered into a settlement with the accused persons. The family of both the sides have now agreed that the victim shall marry with the petitioner. The victim and her parents.
Victim and her mother.
Her-
Mother is the complainant.
Victim and her mother, who is the complainant in the present case, are present in the court and represented by their counsel and identified by them. And they've also filed their self-attested copies of Aadhaar card, which is taken on record.
Yep.
The victim, opposite party number 2, has filed an affidavit before this court, inter alia, stating that she is now 22 years old, 22 years of age, and she has no grievance against the petitioner, oblique the accused. They were in relationship and they are intending to marry. Since the intending to marry, the affidavit is taken on record. From the aforementioned, it remains that the petitioner and the opposite party have not yet married. The opposite party, the petitioner has been absconding in the present case under the fear of arrest. Mr. Raghoda, legal counsel for the state, submits that since the opposite party number 2, who is measured today, has not even married with the petitioner, the judgment of this court passed in Rosaline shall not inure to the benefit of the petitioner. He also submits that recently the Honorable Supreme Court, in which matter also has
In my
taken
criminal appeal number 1451/2024, madam.
1/4
Criminal appeal number 1451/2024.
the Honorable Supreme Court has taken a
So
serious
motor
view,
read petition number
uh,
3 of 2020.
That are converted to criminal.
arising out of arising out of appeal number arising out of Somoto
So moto
Read
read petition number 3 of 2023.
Somoto writ petition of 3 of 2020.
And that has converted to
Taken a
criminal
strong
appeal.
view regarding quashing of the cases where
They are convicted, they have treated.
offenses under POCSO it is involved. Leaves the matter on sensitivity for further consideration. Taking regarding head to the peculiarity of the present case, there shall be no course of action against the petitioner till
Petitioners.
book a master for review. Let us see if you marry that.
Yes, sir.
I have to obtain the CD and a 164.
And
Grateful, ma'am.
meanwhile, the state should obtain the CD of the case. CD of the
160%.
and 1 You do it now.
Let's.
Well, great.
Great.
1 month I am giving you.
Yes, yes.
So that you can marry, settle, and then
Yes.
come and tell so that.
With the calm environment, you can settle. Get full.
Okay.
I may be pardoned, my lord. Wife of the petitioner is seriously ill. If she is
Which
suffering
matter?
liver, my lord, I am making mention for interim.
You can't jump into the court at any time and start mentioning. What is this behavior? Matter is going on. Why can't you come at 10 o'clock? At 10:30? What is this?
I do.
Don't convert the High Court to a Masli Bazaar. Anytime you can barge in and start mentioning. What is this?
I do.
Have some decorum of the court.
Okay.
Matters are going on, you jumping in and mentioning.
Sorry.
I don't entertain this thing, I tell you. You have to maintain the decorum of the court.
Grateful, ma'am.
Yes.
The annexer flag A5, your lordship, kindly glance. The marriage certificate. Flag 5, your lordship, in my brief. There is noting. There is the marriage was already been solemnized under section 5 of the Special Marriage Act, your lordship. The present petitioner is the.
Gyanaranjan Sahu, marriage
Yes, your
officer.
lordship, that is brief.
Also,
Uttam Kumar Jana is the present petitioner, lordship.
Uttam
but
Kumar Jana.
There is already.
Dhritirani, Maba. 18. Yes,
Lordship.
18.
Both they will be-
Where are they?
But let it be it usual, lordship, both the parties will remain present.
Wednesday.
Lordship, diplomat, lordship.
See.
Lordship, item number 3, on behalf of Sushant Kumar Naik, I am appearing he is in personal difficulty.
Sorry?
So, arguing counsel is in personal difficulty, I will argue the matter on behalf of him.
Definitely.
Petitioner here challenging the rejection order of the learned SDGM Jagshampur in GR case number 564/2008.
What is this order? 18,
Order
10/8/2020.
245 for discharge.
Discharge application. Okay. What are the offenses?
Offenses are 419, 420.
What is the ground? Let us see the charge sheet. Let us see the charge sheet. Where is the charge sheet?
Charge sheet is not in my petition.
You don't file the charge sheet. How can I see? Please file the charge sheet. Let us see.
Yes.
Let counsel for the petitioner seeks 1 week time to place on record additional document to substantiate his case. Let him file the additional document. Please the matter.
Lower court can the proceeding may stay or
No, you don't file. If you file an incomplete petition, you are not able to substantiate
If
anything.
they file adjournment.
No,
petition,
nothing.
it can be.
No, don't do that. For the sake of
Okay.
filing, you don't file it. Yes.
Okay, obliged.
4.
Here I'm telling out of a charge, my lord. The offense is 420 and other offenses, my lord. But
You are appearing for?
Yes.
Intervener, informant.
My lord.
Already allowed,
Uh,
copy not, sir.
Two cases are pending, my lord.
It's 420
My lord, one thing.
and why him? He is opposing. Give a copy to him. At least he is entitled to.
I will serve, my lord. But here, my lord, the suit is pending, my lord. Purely civil nature, my lord. Challenging the 15 cell deeds, my lord. FR is also same contention and a suit is pending. Two suits are pending for lower court.
If if you have committed perjury and all while
That is pending two suits, my lord.
maybe suit is a different thing and criminal case will go on. You have cheated. You have cheated. You may file a declaratory suit saying that declare the sale deed to be nullity on whatever ground. That will not preclude him to prosecute you.
Because the judgments are there, my lord.
What judgment? Both the things can go together. Unless it is very apparent, the money transaction and all.
No, my
And
lord.
if he is agreeing, then I can very well do it.
No, that is the
Earlier petitioner also filed CRLMC. In that CRLMC, he request for sent to the mediation to dispute the matter. And the mediation center, he continuously absent. I already annexed.
Where is
the
that?
copy.
Where is that? Show me. That is enough for dismissal. Show me. Earlier he filed what? He watching.
CRLMC.
Watching for the entire proceeding.
Cognizance.
Against cognizance.
The GR also trial already commenced and some witness examined. At this stage, whether CRMC maintain.
No, I'll not entertain, sir. You can't take the court's proceeding like this. Right now. Earlier the petitioner had challenged the cognizance order in CRLMC number 3039 of 2022. This court, by the order dated 1/12/2022, referred the matter to mediation. It appears from the mediation report in that case that the petitioner has not cooperated, as a result of which the mediation failed. Subsequent thereto, the present petition is filed challenging the order dated 10/10/2022, whereby charges have been framed.
Yes, my lord.
Whereby charges have been framed. Charges have been framed. In view of the fact that the petitioner is repeatedly approaching the court and the intervention of this court sending the petitioner to mediation is not availed of, the petitioner is not entitled to any relief, hence the present petition.
Well, in that case,
Yes.
the liberty granted to petition file the petition appropriate stage, my lord. Thereafter, if
However, liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage. Yes.
Obliged.
Item 5.
So in this matter, already the matter has been settled between both the parties. Your Lordship, the last occasion that to call for the under section 164.
Last occasion, leave the matter on 23rd.
नहीं 164 call for करथिले. So
some difficulty there.
You are appearing for?
Opposite party.
Okay. You have taken.
I pray.
1 minute.
Are with me, my lord.
Yes.
Petition.
One thing,
They
Lord, I
supposed
may,
to appear
I,
with this today appear with
I
that. Due to
pray-
some difficulty, they couldn't come. So
No,
that's
that
why
you
like-
tell that. You
Then
tell that. Let
kindly
them
come.
come.
Arjun,
Next week, next.
kindly call for next week, your lordship.
Once you is there.
Fix a short date.
Third date only, next week is.
Short date.
He'll adjust and give it.
Yes,
Don't
high
worry.
low place.
Bring them, don't waste
Yes, your lordship.
court's time like this. Yes.
Item 6. 6 matter because infectious.
Infectious. Infectious. That's the best thing you could do.
Due to long time, my lord, that matter the trial commenced and trial concluded.
Oh.
Item 7.
May I please, your lords? Here in this case, my lord, how the false case has been registered against the petitioner.
Hmm.
The lordship kindly turn to page 9, my lord.
9?
9,
Okay.
the affair.
Yes.
ବ୍ୟକ୍ତି ଜଣକ towards middle. Hey, cognizance is under challenge, my lord.
Okay. But show me the charge sheet.
Charge sheet, my lord.
Not filed.
Charge sheet later on I have got that's why.
You file the charge. You have to file the charge sheet. Then cognizance order, how will I?
Yes, I'll file, my lord. Your lordship, direct I will file a adjournment petition. That
No.
case may be. The lower court date
no.
was fixed to
Maybe,
Tuesday.
Maybe that's your problem. You should have.
My, yesterday I have with
incomplete
the
petition. No, maybe.
charge sheet.
Maybe
Yesterday I have
next week-
received. That's why.
Next week I'm giving. Cognizance order you are challenging, you don't file the charge sheet.
नहीं
and you
चार्ज
ask me
शीट आएगा पछरे पाइली काली
Whatever.
पाइली सर्टिफाइड
That-
कॉपी टा
Mr. Saul and counsel for the petitioner seeks 2 days time to place on record the copy of charge sheet. Let him do so within 2 days. Lease the matter next week, possible Tuesday, Wednesday, whatever.
till that date my lord I will file an adjournment petition your lordship
No,
that much my lord
please don't do that. No indulgence into those kind of matter. First of
I-
an incomplete petition, I am entertaining. Otherwise,
your lordship keep it to 28th.
he'll keep it. Don't worry. There I will accommodate. Don't worry.
Oblige.
You file it today itself so that it will come.
आज कर दो
Ah,
Item 8.
yes.
May I please, sir? The petitioner files his application for quashing of a cognizance as well as proceeding, my lord.
Yes, sir.
Charge sheet is under Annex 2, page 21. For
20.
commission of offense 341, 294, 323, 493,
Yes.
417, 354, 506, 34 IPs. May I kindly turn to page 39, the statement 169 statement of informant, my lord.
Yes.
The victim. My name is so. 2021 ମସିହା ଠାରୁ ମୁଁ ଭରତପୁର ବିନୋଦ କୁମାର ପଣ୍ଡିତ ପିଟିସନ
Where are you reading? 1 minute, 1 minute. You are
Page-
reading page?
page 39 minute 161 statement of a victim.
Yes. Yes.
Since 2021 2021 ମସିହା ଠାରୁ ମୁଁ ଭରତପୁର ବିନୋଦ କୁମାର ପଣ୍ଡିତକୁ ଜାଣେ ଓ ଆମ ଦୁଇ ଜଣଙ୍କର ଭଲ ପାଇବା ହୋଇଥିଲା ମାନେ the informant victim is a married lady and a divorced lady, my lord. Her marriage was solemnized in 2016 and a divorce decree was held on 23. In between, she had gone to the Xerox shop of the petitioner, number 1, and proposed her to and love.
In between when the divorce petition was pending.
Yes, my lord.
Okay.
ବିନୋଦ ମତେ ପୁରୀ ଜଗନ୍ନାଥ ମନ୍ଦିର ଯାଇ ଶପଥ ଦେଇ ବିବାହ କରିବା ପ୍ରତି ଦେଇଥିଲେ ମୁଁ ଭୁବନେଶ୍ୱର ନୟାପଲ୍ଲୀ ହଷ୍ଟେଲ ରହି ଭରତପୁର ପାଠ ପଢୁଥିବାରୁ ବିନୋଦ ମୋ ପାଖକୁ ଆମେ ବହୁତ ଥର ଲଜ୍ ରେ ଯାଇ ରହିଛୁ ବିଭିନ୍ନ ଜାଗାକୁ ମଧ୍ୟ ଯାଇଛୁ.
What are the offenses? 376 also.
No,
No,
my-
493.
493 is the principal major offense, my lord.
And I will have to issue notice.
Yes, my lord.
I'll issue because it can be settled out. Are you now ready to marry?
No, my lord. No, my lord. ये बाहर पुअर petitioner one already married, my lord. ये caste in Brahmin caste and this is an other caste, my lord.
You took advantage of this lady and now
No, my
you're
lord.
leaving her.
Taken it.
Lapse.
There is no allegation in order to trap the petitioner one. She has made this case, my lord.
Upon no trap, whatever.
2021 ଦେଲା.
You are on bail.
Yes, my lord.
Later come, we'll see what can be done. You have to compensate her somehow or the other because now divorce has taken place.
Yes, my
so
lord.
far as her marriage is concerned.
Yes.
Germany.
Okay. Okay. No, you have not implemented her.
My lord, may for you to implement, my lord.
That is minimum.
Yes, my lord. The last occasion I have not.
Learned counsel for the petitioner seeks to implead the informant in the present case as opposite party number 2. She may do so in the. You have a hard copy or you have? Do
Yes,
you have
hard copy. Purna.
He may do so during the course of the countersigned by her. Issue notice to opposite party 2 for 2 Mr. Ragada, accept notice for opposite party number 2. Tick, returnable.
Madam, this case is there no coercive action. Madam.
You are on bail, what no court?
They have further proceeding. Madam, court proceeding.
No, I'll not say, see, nothing is going to happen. I'm giving you one week after. You bring her and I'll decide it.
Notice will go to the
Opposite party number 2. You do it and after 1 week it will be listed. Bring her once notice is served, then we'll sort it out.
Obliged.
Don't worry. Yes.
Item 9.
May I please, Your Lordship? Your Lordship, here I am challenging the order framing charge. Your Lordship, kindly see page 44. That is, my Lord.
Actually, you should have filed a revision anyway.
Yes.
Your Lordship, convert me on my oral prayer. On oral prayer, it can be
Then
converted.
counsel, in the present petition, then the petitioner has challenged the order dated
Order dated, my Lord, 3/8/23.
3/8/23, whereby charges for offence under section
Offense under section 337, 338, 304-A, 201 IPC.
has been framed against the petitioner. He has invoked the inherent jurisdiction of this court under section 482 CRPC. In fact, the petitioner ought to have preferred a revision petition. At this stage, the counsel for the petitioners make an oral prayer for converting the present petition to one of revision petition. The receipt is directed to renumber the present petition.
You have to file consolidated petition.
I will file.
And the petitioners shall file a consolidated petition, lease the matter. Yes.
My Lord, order date 5/2. I have wrongly mentioned 5/2/24.
5/20.
5/20.
5/20.
20. My Lord.
Item 10.
Right, this application seeking questioning of the intercriminal proceeding on the ground that the coacute persons have faced trial and they have been acquitted. And it was listed before Lordship.
You are absconding.
Yes, ma'am.
Absconding.
Yes.
From
And
2000
anticipatory bail application rejected, that has not been disclosed. Service is disposed. 23/3/24.
Not the
Directed surrender. Not come.
And the offense
offense, my lord, 395, my lord, kind of glance to the
395.
from the judgment, my lord, observation of the law.
TI period.
Not conducted. That is, that was last occasion, it was pointed out to your Lordship. And Lordship, my lord, kind of glance to page 51 for a moment, man. Page 51, man. 51, man. That one means, my lord, the just above from para 7.2, my lord.
7.2. Okay. Further prosecution.
Furthermore, the IO PW 11 has admitted in his cross-examination that though the affair was lodged against unknown persons, but he had not appeared before the court for conducting TI parade in respect of the arrest acquittal in this case, which is certainly fatal. And apart from that, so where the PW 2 and 3 are concerned, 4, they are not supported to the case of prosecution, and PW 2 is the informant. PW 2, while lodging the affair, he stated the name of accused Bapi alias Gajendra Patra.
But all these things are qua those petitions.
Petitions,
You have
those
to-
are appeared, my lord.
You never know why they may say something.
They may something.
How do we presume it?
But not completely, so, my lord, kind of glance to the observation.
You are right, because whatever evidence has come on
My-
record insofar as those petitions are concerned, the court appreciated, acquitted them, not trustworthy. But insofar as you are concerned, since you have been absconding, you never know, the same witness may come forward and say something
So
against
my
you.
involvement is, my lord, on the basis of confession of the Gajendra Patra. This is much only material. And your lordship decision is reported in the this month in July part, my lord. Your lordship acquitted the coacute persons, imposing heavy cost, my lord. My lord, reported in 2024, 95 OCR page 1 book is printed, get out a printed copy, my lord. Para 9, para 9 and 10, my lord. Your lordship.
Am I not entitled to commit mistakes?
Nah.
But that was a different thing. I have taken Gyan Singh.
Again, para 9 and 10 is this observation of your lordship. The present case was
When
registered
the FIR was registered?
11, in the year 2011.
Oh, it
And
is
the
2000.
other decision of this honorable court reported in my lord 54 OCR page 544
Oh, see,
in the
these
case of
facts are
302.
altogether different.
No, Seithra, your lordship appreciated the evidence that since they have not supported to the case of prosecution, they might have set your lordship may have
That's
paragraph
right,
9.
but what I have said
And-
is, see, 2000 FIR and other accused persons were put to trial, they were acquitted in 2003. So at this stage, why should I interfere? That was
in the present case was registered in 2011
11
and
and
the-
acquitted on
acquitted on my lord 2022.
22. And even then you were, after 22 also, you have been absconding.
Only basis of and apart from
See,
that,
what I'll do is I'll,
apart from one
you
one
go and
submission,
appear, I'll expedite the trial.
I am not
Within
on bail,
6
man.
months, 6 month.
I am not on bail, man.
Bail, I'll record it, you will get bail also, don't worry. I'll record these things that you have been acquitted, there is no evidence and all. And you appear and within 6 months things will be over. That's the best thing. I think you will get immediately the bail. I'll record everything to get bail.
Yes.
Okay, right on. Petitioner is an accused in FIR number so and so.
May I pray, my lord? My lord, may I diet for first or second hour so that I can move because
That also helps. That also helps.
Your lordship.
Yes.
Thank
Petitioner is accused on so and so. Charge sheet has been filed showing him absconded.
Showing absconded, yes.
Subsequently, after investigation, charge sheet has been filed showing the petitioner as an absconded. There are 5 accused. How
Yes,
many
sir.
accused? Must
5,
be
ma'am.
more than 5, but 3 of them are acquitted. What about the others?
Other 2, my lord. I am for 1. Another was absconded. I got noticed.
Till today, he has not come.
No.
He must be your friend. Why don't you
No,
bring him?
3 have been here.
There are as many as 5 accused.
I am giving
And 3 accused persons were apprehended. They were put to trial. The court of assistant sessions has come CJM Baleshwar in ST case number 20 of 2019 by its order dated by judgment dated 29/9/2022 have recorded acquittal in favor of the 3 co-accused persons. The trial court in that matter has taken into consideration the prosecution evidence and returned the finding that the evidence is not trustworthy for those accused persons, hence found them not guilty for the alleged offences. Since the petitioner was next follow, since the petitioner has been absconding, his trial was split. The trial was split. The petitioner is now seeking parity with the 3 acquitted accused persons. Is seeking the quashing of the entire. I perused the judgment of the 11th court below in passed on
29/9/2022.
29/9/2022. It appears the evidence for the accused persons were appreciated by the court below to record the acquittal. The petitioner cannot derive the benefit of that judgment as the evidences were recorded for the co-accused person to face the trial. Since the petitioner has been absconding since then. Since then, taking into consideration the fact that the FIR was registered way back in 7/8/2011, and about more than 1 decade has passed by now. It would be appropriate that the petitioner's appear before the court on or before 5th of September and surrender before the court of 5th of September and subject himself to the trial, subject himself to the trial. Keeping in view the peculiarity of the human case, I am of the consider view that if the petitioner surrenders and moves the bail application, the same shall be considered on the same day by the trial court. By the trial court. It would be expedient for the trial court. It is expedient in the fitness of the situation. It would be expedient that the trial shall be concluded.
Both party present, my.
Present with respect to the Aadhaar card.
Do you have 164 statement?
No, first time.
164 to देखिए पड़ेगा ना. POCSO is there. Otherwise 354 I would have done it.
Since they have form, lordship can.
No, I'll record their appearance. I'll exempt them. Let the CD come. Let the CD come. Right. Mr. Raut, you are appearing for notice has also not been issued.
No.
So therefore it has to be.
Lordship, as my lords. Lordship short dead.
Mr. Ajit Kumar Raut entered appearance on behalf of opposite party number 2. The file Javakalapnama which is taken on record. Okay. Petitioner is an accused in FIR number 24. Allegation against the petitioner para 2. In the FIR is also. When the investigation is
Completed and charge has been framed.
Investigation in the present case has been completed. Charge sheet has been filed. Subsequent thereto, charges have also been filed.
No, section 352.
Where this stage, the petitioner has entered into petitioner has entered into a settlement with opposite party number 2. On the ground of settlement, a petitioner seeks indulgence of this court for quashing of the entire proceedings. The opposite party number 2, the petitioner and opposite party number 2 have jointly filed an affidavit dated 23/8/2024, inter alia stating what?
Para 4 lords.
Para 4. What is the settlement?
So by intervention of the family members and
what are the terms of settlement?
Due to misunderstanding, this case was instituted.
Stating that due to misunderstanding, the FIR came to be registered against the petitioner, and now to maintain peace and tranquility, they on the intervention of the elders in the family, they have arrived at a settlement. The victim opposite party number 2 is not willing to prosecute the petitioner anymore. The petitioners and the
only
party
sole petitioner. Sole petitioner.
The petitioner and the opposite party number 2 are present in the court, being represented by their respective counsel, and they file their self-attested copies of the Aadhaar card to establish their identity, which are taken on record. Since the taken on record, Mr. Ragada, counsel for the state, submits that he doesn't have the CD to assist the court today. Hence, seeks a direction from this court to calling for the case area for the present case.
One thing I have to mention, they have to add the victim.
Victim is not there. Who is?
354 is there, father of the victim. Since he
Biramaji,
the father of the victim. Since he's the
where is the victim then?
354 is victim is there.
He has come.
Yes, she has come. Story what's going on. If Lordship asks, then I can.
So, in this case, even the victim has not been included as
Since
party. Yeah. Then counsel for the petitioner seeks leave of this court to impede the victim. Minor victim, na?
Minors, therefore he has come.
Minor victim.
Therefore he has come.
Minor victim through her mother. Mother,
Mother, father, as my lords.
Oh, victim card दिया. Victim वाला, impede वाला card. Call for the CD. This is the matter on certainty and the appearance of, now the father can come, why father and accused can come? I thought the victim, I'll let them come, least the matter.
But since he's the minor, he has come.
Well, there may not be 354 is there, so there may not be sexual intercourse.
Yes, madam.
Only some shade something. We'll pass it.
For that,
See it. Next week, CD, you call for one.
further proceeding.
In view of the peculiarity, of the present case, further proceeding, in so and so cases, stay.
Get
Okay. But don't ask for adjournment. I'll vacate the stay.
No, I will never. It is, they have come. If you 1 week after, madam.
1 week after.
On that day, let's see, they will come or.
Yeah, let them come. What?
Okay. Yeah, grateful.
Yes.
13 on behalf of Mr. Behera, as he is only legs pass over, my lord. Item 13.
My lord, I may be pardoned, my lord. It is a trap case, my lord. It is a trap case, regular appeal. But the IA is supposed to be affidavit is to be filed, but no affidavit has been served on me, and no stay of realization petition has been filed.
My lord,
Is the press one?
Yes, press one.
That's appeal.
Yes, my lord.
Sentence
Press
how
appeal.
much? Sentence
Sentence
how much?
2 years. 2 years on 13(1)(d) and 1
Okay,
year on.
I'll admit it to
My lord, in the meantime, another IA has been filed. My lord.
get about that.
No copy has been served.
You supply the copy. I'm
During
staying
the
in
course of
proceeding. Admit, granted bail, realization of fine is stayed.
My lord, my name may kindly be reflected on the top of the brief as well as in the cause list henceforth.
Yes.
I'll
Usual
supply
order.
during the course of the day.
And supply the copy during the course. Yes, allowed. Yes.
Obliged, man. A free copy of the order may kindly be supplied.
Yes, he will supply today, sir. Yes.
Obliged.
Under section 120B, 420, 409 of IPC, read with section 456 of
Yes.
Prevention of Money Laundering Act, my lord.
Money
And the present case, in pursuant to the direction of the Honorable Apex Court, had order dated 9/5/2014 passed in
You
the
tell me what
case.
yes.
My lord, the allegation is that the
What Supreme Court has said.
by the order of the Honorable Supreme Court, this present case has been instituted, and it was firstly registered in the
You're in custody since?
Custody since, my lord, 31/1/2020. The charge sheet submitted on 31/1/2020, my lord.
20. And you are in custody, huh?
Custody. And the charge sheet was submitted on 8/2/2017, my lord. As per my instruction, the trial has not been progressing, and out of 315 charge sheet witnesses, only 10 to 15 numbers of witnesses have been examined, my lord. I have applied for the deposition copy, my lord.
You want an adjournment?
If
You get those things because under the intervention of what is the extent of fraud?
Extent of fraud, so far as the specific allegation as against the
No, you tell me the amount. Don't bring.
total allegation is 86,29,557.
How many people you have cheated?
About those are 67 investors, my lord. And as per the charge sheet, there are only 3 accused person, and out of those 3 accused person, the main accused person has pleaded guilty and convicted for a period of 5 years, my lord. And the present accused person who is in custody, he has already been custody for a period of 4.5 years, my lord.
4.5 years.
Half years. Main accused person has been convicted for 5 years. I am in custody for a period of 4.5 years, my lord.
The offense is under 420.
420, 409 is there, 120B is there.
No, 409 is there.
Is there, but my lord, the main accused person who has pleaded guilty has been convicted for only 5 years, my lord.
But what are the offenses?
Same offenses, my lord, same charge sheet.
Then why don't you employ that 446 capital A?
My lord?
446 capital A. 436 capital A, I think. 446 or 436? 436. 36. 436 capital A.
I bow.
You research on that. Mr. Mishra is there to assist you. Just ask him. And 436 capital A, if the main accused who has pleaded guilty is sentenced for 5 years, more than 50% you have caught, you guys can take to bail.
On judgment, Surendra Raul Sarathiva case.
You take Mr. Mishra's help.
That is there. Okay, clearly what your lordship is saying.
Straight.
Surendra Raul versus State of Odisha.
Why are you going here, there, and
Directly.
you will get bail immediately. Wednesday?
Yes, ma'am.
Wednesday, Thursday जब भी करके डाल दो, नहीं तो गुट्टे 1 week after this, 1 week after this, better 1 week after. And take your senior's number and get those judgment. And the other line of judgment, if you are getting more judgment, recent judgment, give it to him also. Okay? And you concentrate only on that. You are going to get the bail. Yes.
My lord, item 11, my lord, as held up in court number 8.
Pass over, 11? Pass over.
Yes.
Yes.
May it please your lordship. My lord, in this case, your lordship, there is allegation under 302. Your lordship may kindly permit me to place the order dated 6/8/2024.
Yes.
Purely, my lord, planting. This is a purely
6/8?
6/8/2024. Just the last order.
Undertakes to file the charge sheet.
That I have already filed.
PW1.
No witnesses are turning up. Even in the impugned order of rejection, the learned trial judge has expressed displeasure that the person is in custody since 3/8/2022. 3/8/2022.
Okay.
My lord. Even in the impugned order, the learned trial judge has said and called for an explanation from the bench clerk concerned as to why it is happening. I have got the entire order sheet also to show that no witnesses is turning up. Now, one witness has turned up, who has been turned hostile. Your lordship may kindly see, there is an allegation against the petitioner.
Was the report sought from the trial court?
That your lordship directed the learned state counsel for the state is directed to obtain instruction regarding the present status of the case by the next date.
My lord, it has not come, my lord. Just my lord, last chance, my lord.
Then what I'll do is I'll call for a report from the concerned court.
I'm placing if your lordship, because my lord, the thing is that
No.
on
What
the-
I'm telling you something in your favor. On the basis of the report of the trial court,
Yes.
you can use that judgment of Ravi Prakash for grant of bail. If it's not moving, it is not attributable to you, then you are entitled to bail. We can utilize Ravi Prakash for enlarging your bail, but that can only be done after the report of the concerned court comes. I'll ask for a report within 1 week. In any case, is asking for time. Then you read Ravi Prakash. And
because on the last occasion when I submitted charge sheet, your lordship expressed displeasure over the matter that how a deceased person can be witness number 1. That is Anita Naik. Your lordship may see charge sheet.
I know.
So your lordship said you want to examine her, you examine, please. That is witness number 1, my lord. And what the bail order says, I have stated before my son, who is 14 and 17 years, 2 boys, that I have killed her. This is what I have stated before them. 164 of the son is recorded. He is not a charge-sheeted witness. Lordship may kindly see the way they are doing, my lord. Let him come, I have no objection. Knowingly, because they are planting me, knowingly they have omitted him to be a charge-sheet witness. The charge sheet
that is the extrajudicial confession is read against you.
164, my lord. That is what the learned trial court said, that the boy gave 164 statement against me. In that case, your lordship, he is required to be the very, because he is 14 years old. He is not a small boy.
So they are dropping him.
Yes, your lordship. And informant has engaged advocate even. It is not that, my lord, I can say.
At least in the peculiarity of this case, he is at least entitled for bail, conviction and all these things, leave it to. I'm giving you only 1 week. And this Monday I'm leaving, next Monday I'm calling for a report from the concerned court. Call for a report from the concerned court. Call for a report. Mr. Rahul submits that pursuant to the earlier order, he could not obtain the instruction regarding the present status of the case. Thereafter, call for a report from so-and-so, leave the matter, and it made clear that on the next date of hearing, no adjournment shall be granted. Yes. This either you keep it on the Friday, coming Friday, or Monday. Okay, so that Monday, that means I'll tell you, 2nd. Keep it on 2nd.
2nd of September.
It's made clear that no further adjournment shall be. Yes. Yes.
Can my lord copy not serve, my lord?
Copy not serve, adjourned, yes.
17.
So in 17, my lord, the two matter I am appearing for the petitioner, that is BLPL number 13820 2023.
Yes.
And another is 5395 of 2024. I want to file some document, my lord.
Mr. Sahu, learned counsel for the petitioner, seeks an adjournment to file additional document to substantiate his case. 1 week time is granted. Least it after 2 weeks. Huh?
Great. The two matter may kindly be
Both the matters. Which one?
The BLPL
Both the
number
matters. Yes.
13820 and 5395.
Yes.
Grateful.
Yes.
Item 18.
Yeah.
Yes, sir.
From 18, my lord, there are two connected. Another, my lord, the sub item, my lord, 13607, my lord. I have
How many
filed-
cases are there? 1, 2, 3, 4, 5.
I have filed an interim bail in the sub item.
But let us see first of all,
And
this is a 302.
Yes, my lord.
302, 5 accused.
I have filed an interim bail application, and in the coordinate match in another bail application, I have filed an interim bail. This is related to two cases. I have filed an interim bail. On that case, he has been referred to MKCG. So that case has been also adjourned for calling for a report. I will produce some document. Kidney has been transported.
Then let us see if you are basically entitled to bail or not. Otherwise, I'll dispose of this bail application, relegate you to trial court for interim bail.
But in the coordinate bench also adjourn the case for calling.
Maybe coordinate bench might.
That's why I felt I prefer one.
I'll look into that. What is the matter?
All the matters may be tagged up together. That my lord, the super killer who has taken money to kill the person, subsequently demanded 1 crore rupees. He was killed at Hyderabad. Then after the
That is based only on circumstantial evidence.
Little good discovery is there.
Are more stronger than the.
No, circumstances in the sense only confessional statement. There is no leading.
What is the stage?
Gone, my lord.
Leading to discovery. What is
1 minute, let him complete. What is the stage of the trial?
Stage of the trial, my lord, that instruction is no. He may say that what is the
What is
stage
the
of the
stage?
Trial not started. Trial not started.
Take also instruction.
FIR registered on?
There are 5 items.
Yes,
Plus
5
various
items.
partners.
FIR is
My item is third sub item third lordship. That is BLPL number 985 of 2024 lordship. This case lordship, I am in custody since 1/7/2023 lordship. The only matter against me, that is the confession of the main accuser Ajit Krishna lordship. The case lordship, the present disease, in that case present disease, he has he hired by the one Ajit Krishna to kill one Gauri Mishra lordship. And accordingly, as per their plan, the Gauri Mishra has been killed by the present deceased. And in that deal, your lordship, there was 30 lakhs deal. And only 1 lakhs have been paid by the main accused to the deceased. And after commission of that crime, your lordship, after kill the Gauri Mishra, he demanded rest 29 lakhs, your lordship. To pay that 20 lakhs, your lordship, the main accused Ajit Krishna called the present deceased to Visakhapatnam. And there he has killed him. That is the case.
that what is happening to Visakhapatnam case?
This is the case.
Case was registered, my lord.
This is the present case,
the
lordship.
present
This is the case in connection with that murder, lordship.
And that
Hey,
present
that
case-
murder has taken place in Visakhapatnam.
My lord, the
First one is
Gunapur, next is Visakhapatnam.
my lord.
And there must be some case in Visakhapatnam also.
No, my lord.
That was the leading to discovery was from Visakhapatnam.
Because the fact that the mother of the deceased, my lord, she lost the affair in the Odisha, at Gunapur, in the under the jurisdiction of Odisha, my lord. It was registered in Odisha. And during investigation of that particular case, it has been found that the deceased has been murdered at Visakhapatnam.
This is the case.
And
There are two FIRs then.
Two FIRs.
Release done by the first case.
To affair, all the persons were before some court relating to the offense which occurred at Visakhapatnam regarding that killing of the hired person, hired killer, my lord. And so far the materials is concerned, my case-
You give a chart, whose role is what?
My
Otherwise,
lord, I will-
we are
some
wasting
cases,
our
my
time
lord,
like this.
I will-
We can't.
All the matters, my lord, may be tagged up together.
All the matters are already tagged.
already tagged.
Just see. And last time also I told you that give what is the role of each individual, because we have to see individual cases.
Yes, my lord.
We can't in one breath, we can't say that.
No, my lord. Yes.
And all have come after submission of charge sheet.
So therefore you prepare a chart and give me. At
My
least
lord,
least it up to 1 week.
If you examine page 83.
I'll check one after another.
Only concession statement of the.
Whatever, but see, it's not so easy for you. There are two murder cases. I have to see each individual case.
Two murder cases, one murder case,
One murder.
separate affair. The persons are not being.
But there are two deaths.
Again.
Yes.
No, two
Who has
deaths.
committed the
Confused
murder.
for me.
He has been murdered.
Anyway, there are two murder.
Two murder, two
People
persons.
are involved in giving money, hiring super killer, and so many things happen. So I have to check every individual role of it.
May please sort that next week.
He will give it.
Again, next.
1 week after. ଆପଣ ବନେଇ ଦିଅନ୍ତୁ.
Yes, yes.
ଚାର୍ଟଟେ ବନେଇ ଦିଅନ୍ତୁ. Third of September. 3rd September. 3rd September.
My lord, 3rd September, it may be 2nd or 9, my lord. Because, my lord, in the week, if it will come on the weekly list,
Second,
it will be
second,
easier
second,
for us to
second,
prepare.
second.
Because if it will come on supplementary list, my lord,
Difficult. He's playing for second. Well, no problem. That issue. Second.
Second.
Fine.
Okay. Yes. 19 or 20 or 22. Huh?
19.
Up to 20.
Your Lordship, in item 19, I pray for a short adjournment, Your Lordship.
In item 19, my lord. I am appearing on behalf of the informant.
19.
Yes,
He is asking for adjournment. Yes. Bail matter.
May I please, Lordship?
Yes.
Lordship specifically directed State Council to obtain the chemical examination report of viscera to ascertain the cause of death.
Yes.
In the meantime, charge sheet has been filed and PP has been supplied to me. From there,
What is that?
examination report says there is no chemical compound found in the viscera and the cause of death is due to cardiac arrest.
So custody
Since, my lord, 20th November 2023.
Yes, my lord. Have you seen it?
Yes, my lord. Yes, ma'am.
Then cardiac arrest.
Cardiac arrest.
What is the allegation? Other
Allegations, my lord, the deceased, while cutting a trunk of a tree, he cut one of his fingers of leg. Then the family member immediately took to the petitioner. He is a quack in that area. He gave an injection. It is alleged. Thereafter shifted to the government hospital. During treatment, he died. Then one of the villagers, he alleged the injection memorial.
Yes.
This is the allegation.
Question was
But now this report has come.
Report has come,
Yes.
and in the meantime, my lord, some few days back, it has
Poisonous compound,
not found.
alcohol and drugs by chemical. And this is poison compound of alcohol. Now, where are you reading then?
Lordship may see detection
had-
of poisonous compound and alcohol occurs the method. Next, poisonous compound, alcohol and drugs could not be detected. That I marked, my lord. Outcome. And also,
Right. Petitioner is accused and so on. Allegation against the petitioner is like that. Okay.
in custody since 20th November 2023.
Chemical analysis report obtained from State Forensic Science Laboratory, Rasulgarh, has been handed over to the court for perusal. The perusal of the report, the report. In the report, it is the report indicates the following.
I have marked, my lord, that. Outcome.
Person could not be found.
And last page, the cause of death has been ascertained as cardiac arrest. Lordship.
if the report also indicates, the medical evidence also indicates that the death of the death of the deceased victim has caused due to cardiac
Cardiac
cardiac arrest. The report for the final opinion of the doctor reached ये ठीक है.
My lord, just now, the before the case has committed, the case number has changed. Sessions case number.
Let me come
My-
there. You want that it should
No,
be rejected or what?
No, my lord.
Wait, let me complete. The petitioner is in custody since 20th November 2023. Granted bail.
Sessions case.
14th season.
Session.
I'm right.
My lord.
No problem.
Okay.
And
Oblige.
number of FIR and everything is all right.
My lord.
14th season and same additional condition that he will cooperate and all. See,
Oblige, deeply oblige.
I just come.
My lord.
Item number 21.
21.
Yes, 21.
Yes, I adjourn it since you are not appearing. Anyway, what
Sir.
do you want?
The matter is under section 498A, 304B, 306 IPC, along with
Yes.
4 of DP Act. And the accused is in custody since 10th April 2022.
10 April 22.
Sorry, sir. 23rd March 2022. 23rd March 2022.
22
March and
23.
My lord.
Okay. Yes.
Oh.
Your husband.
I am the husband. I'm the
That's
accused
right.
person.
What are the allegations?
My lord, date of arrest is 22 March 2020.
22.
Yes, my lord.
22.
Yes. What are
Since
the allegations?
Sir, allegation is accidental. The burn injury inflicted on the body of the deceased wife is accidental due to the bursting of the stove. And I have already filed the deposition of 8 witnesses.
Out of 38 only.
8 witnesses.
And show
My lord-
me from the evidence whatever you are saying is
Yes, my lord,
Exactly.
PW8 and PW7 are the neighbors of the accused persons. In para number 3, they stated that the accused and the deceased living happily.
no, that's happily immediately after marriage, happily everybody is happy. Thereafter,
No,
what
but,
happened?
no, sir, it is the marriage was
You on the date of incident, any eyewitness, anything, anybody is there? You show me that.
no, there is no eyewitnesses.
Yes, what are the materials?
My lord, I may be permitted to read the deposition of mother of the deceased man. I know I am the.
Read the relevant part.
Yes, ma'am. My daughter lived happily with the accused for some months and prior to the 3 years of marriage. The accused person quarreled with my daughter and assaulted her. The accused person assaulted my daughter, demanding motorcycle, fridge, and money.
Come to the incident. Demanded dowry is all right. Incident, what had happened?
Just exactly. I asked and torture to the assault for more dowry over telephone. I asked my daughter to live with the accused person and try to adjust with me and express my inability to meet for further dowry. On 6th day of October.
What have you recovered? It is a burn injury by stove.
My lord, only carrying to the hospital, my lord, that the deceased has expressed before her mother that the petitioner has poured the kerosene to.
Dying declaration.
Yes.
Will show me that.
There is no dying declaration, my lordship.
1 minute.
I met my daughter at VSS Burla and on being asked, she told me that accused person poured kerosene and set her on fire. Thereafter, the doctor referred my daughter to Kata for better treatment. When I reached Burla, I found my daughter was admitted at VSS Burla. The 11th day of the month, my daughter expired.
Are you harping
My lord-
upon the, 1 minute, madam. Are you harping upon the evidence of the mother of the deceased, or you have any other material?
Normally, other witnesses are more.
See, after the death of the daughter, she may say, where is the dying declaration, whether you recorded from the spot, what have you recovered? Kerosene stove, who is using kerosene stove nowadays? From spot, what have you recovered?
But my lord, there is a my lord, my lord, that is the
Where is this incident? Where is the place?
in the place of
In the house of the accused person.
The place.
and we read the Dr. Abhipsa Das, the relevant part, my lord, the state forensic laboratory statement matter. My lord, they are within the distance of my lord. Police said crime was committed in front of the house of the accused nearby the main entrance iron door on one empty plastic jar of the capacity of approximately 1 liter labeled as Glucon-D with open lead was noticed nearby the jar, having smell of a suspected inflammable substances, kerosene, like one matchbox labeled as AM having unburnt matchsticks.
Okay, I understood. Yes, madam. Tell me.
Sir, there is
Sundargarh.
yes.
Who is using kerosene stove nowadays? You tell me.
No, sir.
Why kerosene was found? Everybody used gas.
Yes.
Where
Kerosene,
from you got the kerosene? Why kerosene was there?
remote area. Sir, it is the remote area, the village area. The house is in the village area, sir.
Oh, that is Sundargarh. In village area
sir.
also there are
Village area. Yes.
nobody use kerosene stove nowadays. Getting
It
kerosene
is in
is
village area.
more difficult than getting gas.
More costly and
Sure.
difficult.
Nobody use kerosene, and the kerosene is kept means it is very serious thing. That's the
Moreover, sir, there is no dying
So how many
declaration. My
witnesses
lord.
have been-
My lord, only 8
There is no
witnesses
dying declaration, my
out
lord.
of 30.
material witnesses?
Material witnesses, my lord,
There are no other material witnesses. The mother of the deceased and the father of the deceased are already been examined.
my lord, I mean,
All
that
right.
hostile.
My lord, in 161 statement, my lord, in 161 statement, ଏଇ ଜିନିଷଟା ନାହିଁ my lord, କି ମତେ ମୋ ଝିଅ ଦେଖା ହେଇଥିଲା କହିଲା ଯେ ମତେ କିରୋସିନ ପକା ହେଇକି ମରା ହେଇଛି। ଏଇ
Madam,
ଜିନିଷଟା
I'll tell you, if it is a case of hanging or poison and all, I find out the way to give
accident, it
the
is purely an
I'll say,
accident, sir.
What accident, then how kerosene has come?
Sir, it is a very remote area,
You
sir.
burned the-
Kerosene is found in every village area, sir.
No. Don't
My
tell
lord-
it all. Kerosene
my lord-
nowadays is not found. It's very serious. Otherwise, I could have granted you bail. That's the problem, right?
My lord, he's in bail since 2. My lord, he's in jail since 2 years.
Allegations and the recovery from this nature of allegations and the nature of allegation, I am not entitled to enlarge the decision made. Mr. Rahul will counsel for the state submits that out of 38 charge treated witnesses, 8 witnesses have already examined. There are a couple of material witnesses still to be examined in this matter. Hence, the petitioner is granted liberty to renew bail application after the examination of all the material witnesses. Since the FIR is
My lord,
FIR is for 2000. Since the
para
petitioner
5 of PW1, my lord.
since the petitioner is in custody from 22/3/2022, it would be expedient that the trial court should do well to see that all the material witnesses are examined preferentially over the formal witnesses. If the material witnesses could not be examined within the stipulated time frame of 6 months, the petitioner can also revive her bail plea. His bail plea after the expiry of that period. With that observation, the petition is disposed. Yes. Yes.
23.
See, may I please your lordship? My lord, last occasion, my lord directed to obtain the 164 statement of the victim, my lord.
Yes.
Allegation is that as per the affair, they have law of affairs with the petitioner.
Your
with the
custody since?
Custody since, my lord, 1911-23, my lord.
23.
The victim is a working lady.
26. The girl is a working lady.
My lord, but 17 years, 9 months. The age of the victim is 17 years, 9 months. As per affair, he
Read
is
164.
Yes, ma'am.
Read one.
ମୁଁ ଅମୁକ 1931 ଏଠାରେ ଉପସ୍ଥିତ ହୋଇ ମୋର ବୟାନ କରୁଛି କି ମୁଁ ସମ୍ପୂର୍ଣ୍ଣ ବଡ଼ ରହିତ ଜାଣିଛି ପିଟିସନର ବର୍ଷ ଉପରେ ହେଲା ତା ସହିତ କଥା ହେବା ମୁଁ GITM ମେସରେ କାମ କରୁଥିଲି ସେ ମୋତେ କେତେଥର ତାର ଜିରଙ୍ଗ ଘରକୁ ଡାକିଥିଲା ଓ ମୋର ସହ ଜବରଦସ୍ତ ସାରି
Oh, charge sheet has been filed in the present case on charge sheet.
My lord.
Now you read.
372N and
No, date you tell me.
16/1/2024.
16/1/2024. Since the bail plea of the petitioner was rejected when the investigation was going on, subsequently the charge sheet has been filed. The petitioner is granted liberty to renew his bail plea before the court of first instance. With this observation, the petition is disposed of. Yes. Next.
24.
Yes. 24.
24, my lord.
Hmm.
20B2C, my lord, 10 kg ganja. In the last occasion also, petitioner was not appeared, and today also. My lord, only petition copy is there. 10 kg and petitioner is custody since last.
But I can't see the bail petition. I can't dismiss it for default.
10/16/10/2023 custody. But 16/10/2023, my lord.
10/23.
But the petitioner belongs to the UP, my lord. So that's why nobody is there. No, council is not there. No, nobody.
10 kilo.
10 kilo only.
Is entitled to bail.
Purchase, my lord.
Why? I don't know why. Pass it over. Let's see. 10 kilo is entitled to bail.
Yes, my lord.
And nobody is appearing.
Last occasion also, my lord.
And it is not fair to dismiss the bail application on default.
25.
There are pass over.
45, my lord, not press, my lord.
Not press. Thank you. Not press. Yes.
26.
My petition.
Yes.
Petition is the complaint. FIR was law under section 304B, 302, 294, 50. Custody, I mean, in my lord, 4/9/2023, my lord. 2023, my lord. And the marriage is, my lord, 9/2/2022. After marriage,
Forget
allegation.
the charge sheet.
Charge is submitted on, my lord, on dated 24/12/2023.
Okay.
So BC 12/2000.
How she died?
Poisoning and then its complication. And
Poisoning.
my lord.
Medical.
And
medical
the present petitioner, my lord, himself, my lord, took the disease to the medical, my lord. It is revealed from the statement of the witnesses, my lord. And so far,
she herself consumed it.
my lord, no, the husband has took the disease. Yes.
She herself consumed.
My lord.
When the husband came to know, he took
Immediately shifted to the
so
hospital.
the medical.
Yesterday, your lordship has discussed that the reason behind that alcohol. Whenever the husband took the alcohol and came into the house and assault to the wife, and then thereafter
This satisfied
This is-
marriage, but
This is not that case, my lord. There is no iota of evidence.
show me the medical.
My lord.
Medical evidence. Do you have medical evidence?
Yes, ma'am.
What is poisoning? What is this poison?
My lord, the above mentioned internal findings of the stomach are antimortem in nature and could have been caused due to the congestion, toxic and noxious irritant substances. Cause of death could have been due to the poisoning and its complication thereof. And however, the routine viscera has been preserved in the container.
Viscera has not come. You show me that she has taken herself.
My lord.
To me. Where
My
do I get it?
Lordship may kindly turn to page number 24.
24.
Yes.
Yes.
I am reading relevant portion
Who
only.
is he?
My lord, he is the one of the witnesses, Sridhar Ojha.
Yes.
ତା 31/8/2023 ର ରାତି ପ୍ରାୟ 1 ଘଟିକା ସମୟରେ ଭାଗୀରଥୀ ବେହେରାଙ୍କୁ ତାଙ୍କର ଜ୍ୱାଇଁ ଶକ୍ତିକାନ୍ତ ବେହେରା ଟେଲିଫୋନ କରି ଜଣାଇଲେ ତାଙ୍କ ଝିଅ ଇସ୍ପିତା ବେହେରା
Where are you reading, sir?
my lord last 5 line my lord
Okay. Yes.
ବେହେରା ଦେହ ବହୁତ ଅସୁସ୍ଥ ସେମାନେ କଟକ ନେଇ ଯାଇଛନ୍ତି ତେଣୁ କଟକ ଯିବାକୁ କହିଲେ ଭାଗୀରଥୀ ବେହେରା କଟକ ବଡ଼ ଡାକ୍ତରଖାନାକୁ ଯାଇ ଜାଣିବାକୁ ପାଇଲେ ତାଙ୍କ ଝିଅ ବିଷ ପିଇ ଦେଇଛି ଆମେ ସନ୍ଦେହ କରୁଛୁ ଇପ୍ସିତା ବେହେରାଙ୍କୁ ତାର ସ୍ୱାମୀ ଶାଶୁ ଶ୍ୱଶୁର ମିଶି ବିଷ ଦେଇ ମାରି ଦେଇ ଥାଇ ପାରନ୍ତି
Show me that she has taken herself. She has taken the poison herself. Anything.
No, to that effect my lord no evidence has been collected my lord
Do you have
only it is
must read those portions. Any independent witness?
No, my lord, all are.
every witness has stated so my lord.
Viscera report, when are you going to get viscera report?
And chassis submitted my lord deleting the 302 my lord.
Keep it after 4th of September. Huh? Viscera awaiting Mr. Rahul and counsel for the state submits that viscera report in the present case is still awaited. Leave the matter after 4th September I am keeping because 1 year you will cross. Then I will get to wait. Therefore I am keeping it. Okay. 6th, 7th is okay. 6th, okay. 6th. At least 1 year is over. I can write 1 year is over. Okay.
That is the discretion of your lordship.
Viscera report you try, Mr. Rahul. Mr. Rahul, you try and get the viscera report by next database. Yes. And find out somewhere, one sentence somewhere where I can get that she has consumed.
No, here my lord.
You find out nowhere. I know that. That is why I am telling you to find out.
My lord.
Then I'll reject it now.
No, I will find out my lord.
I am asking you to do something for yourself. You no.
ନା ମୁଁ ପଢିଛି ତ ଆଉ ଥରେ ପଢିଦେବି
Is it necessary that for everything you should know? Say,
My lord, I will find.
Hear the full sentence, what I'm saying. Find out some line where out of all the witnesses where I can get a feeling that she has consumed herself.
My lord.
I'll record that and grant you bail.
My lord.
Don't say no. Then I'll say also no.
No.
Yes. 27.
May blushment. Petitioner is in custody since 31/7/2023, my lord.
31/7/2023.
7/2023.
Yes.
4-line, the 164 statement, she has not stated regarding sexual assault. 4 line of statement, their last order, my lord, kind of a glance. The 164 statement is with my lord and senior.
Yes.
And in the meantime,
out of 17 charge witnesses,
I have given my lord
5 witnesses have already
depositions
been
of PW4, who is the victim. My lord, kind of a glance to this statement.
Against the petitioner, the statement recorded 164. However, they entered into the witness box and trial court and he has repeated the version as yes.
Last
Yes. In this case, what had happened is 161 she has not said anything. In 164 she said everything.
No.
In 161 she had said something. 164 she had not said anything. When he came to witness box, he repeated 161.
161, and in the cross-examination, she stated that paragraph 5, my lord, kind of glance, paragraph 6, I have placed before your lordship, paragraph 6, that she stated that what I have stated before the magistrate, that was as per my own will. After recording of my statement by the magistrate, I also read the same and appended my signature.
Yes.
What the magistrate recorded in exhibit P/5 by PW4 is true. And next para, he had been
He is PW
4.
4.
से निजे कहूँ जे magistrate पर मुझे जहाँ कोई
Read 164 then.
164 my lord, 4 lines.
164 will come to your aid.
Yes, my lord. I 164. ମୁଁ ଗୋଟେ ପିଲା ଲିପୁ ସାହୁ ମୋତେ ମହାବିଦ୍ୟାଳୟ ଯିବା ସମୟରେ ବହୁତ ହଇରାଣ କରେ ଏବଂ ମୋ ଠାରୁ ପଇସା ମଧ୍ୟ ମାଗେ ତାପରେ ମୁଁ ଥାନାରେ କେସ୍ କଲି. This is 3 line.
Yes, sir. Yes,
Denied for medical examination.
Right. Petition is accused on so. during investigation, the victim, the statement of the victim under section 164 CRPC was recorded. C inter alia stated, 164. Read it out.
ଗୋଟେ ପିଲା ଲିପୁ ସାହୁ ମତେ ମହାବିଦ୍ୟାଳୟ
One inter alia stated that one boy named Lipu Sahu
ମତେ କଲେଜ ଯିବା ସମୟରେ ହଇରାଣ କରେ
used to tease me while
And-
going
and
to the
taken
going to
money.
college. Yes,
and taken money from her
and also taken money from her.
for which
Money for
he,
her. Full stop. Except these two lines statements, he has not uttered a single, he has not made a single allegation against the present petition. However, when she was examined in the court as a PW4,
yes ma'am.
PW4, she has reiterated her statement as recorded by the police under section 161 CRPC. However, in the cross-examination, which part?
Paragraph 6
Cross-examination in paragraph 6, she has stated that what inverted comma, right? What I have stated before the magistrate that I was as per my own, that was as per my own will, full stop. After recording of my statement by the magistrate, I also read the same and appended my signature, full stop. What the magistrate recorded in exhibit P5 oblique P5 oblique PW4 is true. 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 Taking into consideration the aforementioned, I am inclined to enlarge the petitioner on bail. Petitioner bail. The petitioner is in custody since 31/7/2023. Granted bail. Yes. Next.
Madam, though 3 is there in that case, madam.
He is
So the informant is appeared, that may be required.
Informant also appeared. Yes. 28. 376 AB.
376 AB, madam.
AB 506. None appears for the prisoner in the interest of justice at that October. Yes. 29. Yes, 29. Yes.
May I please your lordship?
Mr. Patnaik, yes.
Your lordship has covered this matter. This is the offense under 22C of NDPS Act.
What is the recovery?
800 gram.
800 gram.
153 kg, 800 gram.
Custody?
Custody is year
Custody is
2021.
June 2021.
He is from Bihar. On the last occasion, lordship directed that to how your lordship was inclined to grant him bail. But the condition your lordship asked, what
You tell me the
can be
condition.
imposed.
See,
That
because-
condition, my lord, you're already one of the accusers released who was outside the state. Your lordship imposed
Well,
some
merely
condition.
because somebody belongs to some state, they are also citizens. They are also having the liberty. You can't.
Only that they will be appearing in the trial. That is the sole motto, my lord. The trial should not.
So
be-
you suggest what condition should be?
Already given, my lord. Your lordship has already allowed one
case I have already.
outsider. Your lordship granted bail.
Outside state, huh? वो वाला condition करो. He is in custody since
Custody since 23/6/21.
23.
24th June 2021.
What is the stage of the trial?
My
What is
lord,
the stage of the trial?
one witness has been examined, which was not supported to the prosecution also, my lord.
Only one witness, huh? So he petition is in
My
custody.
lord.
23/6/2021. Out of how many witnesses? Charge sheeted witnesses.
Sorry, my lord, I have not written 18 something.
How many charge sheeted witness? You want to argue a matter in the High Court without preparation. These are minimum things. You should know it. What is this?
My lord.
Everything you will do here in the court only. preparation, everything.
I'm sorry, my lord, I have.
Next week. Next week. Unnecessary. We have charge sheet here. We just see charge sheet is there or not. These people don't prepare anything. That's the whole difficulty. Do you have the charge sheet with you?
No, my lord, she has not annexed in, only rejection order.
If you utilize Ravi Prakash judgment, then you need to know how many witnesses are there. I am passing it over, just check it up, how many witnesses are there. I'm passing it over at 2 o'clock, I'll take it. 30.
My lord, my custody since
21 rows. Yes.
My lord, my custody since 22/10/2023. Offense under section 373. 22/10/2023.
My lord, here, my lord, that notice was issued, but it was not.
No, 1 minute. वो जो अगरू जो मेटर था ना 29. Let us call for a report from the trial court.
Yes.
Right on. Call for a report from the trial court regarding the status of the trial. Then we'll see how many witnesses are there, how many. Yes. List it after 1 week, huh? Yes. Yes, 30th. Yes.
My lord, offense of the charge sheet is submitted on the 19/12/2023. 19/12/2023. For the offense under 373, 294, 506.
Yes.
And 4 of the POCSO Act.
Yes.
And though notice was served, my lord, as for lordship direction, I filed the requisites, but till the informant has not appeared.
Not sufficient.
My lord. Taken up.
My lord, I will take
steps.
My lord, I will take instruction that whether notice was served.
Step and he will take instruction. Yes. Next.
My lord, next week, my lord.
And next week, 1 week after. 1 week after, my lord.
1 week after. Yes.
31.
May I please? Dear my lord, case under section 302. Petitioner is in custody since 27/8/2023, my lord.
27/8/2023. Yes.
And there is, my lord, no eyewitness to the occurrence, only on the basis of implication is.
How many accused are there?
There are 37 witnesses and none of the witnesses were examined till date, my lord.
Accused, how many accused?
No, only person.
Only person, my lord. Here,
Reason is that, my lord, that that damage of crops by grazing the cows, that the disease has grazing the cows and for which the crops was damaged.
No, this is the allegation.
Informant, that the present petitioner, he has kept a gun to protect the crops from the wild animal. In that gun, he has killed the disease.
What happened, my lord? In 2022, this petitioner is a cultivator, my lord, and he usually cultivate corn crops at the his land. And the present accused, deceased is a they heading cows in the village area, and knowingly intentionally. This is the prosecution case, the brief facts of the case of the charge sheet. He in 2022 he also damaged the corn crops of the present petitioner by herding cows into the field. And thereafter, there was a dispute, and that was again, intentionally in the year 2023, he intentionally sent his cows to the corn crop of the present petitioner. And there was
the
deceased, and the present petitioner is a cultivator. He usually
he fired.
Thereafter, the present petitioner
and that cultivated land belongs to government land, my lord.
And
not
the present petitioner, this is the allegation of the prosecution, kept a gun, country-made gun, to protect himself and the crops from
I
the
understand it, he fired it.
wild
And,
animal.
yes.
This is the allegation, and on the basis of this allegation,
Right.
the present petitioner is in custody.
Yes.
And there is no eyewitness to the occurrence.
Then it makes the case worse. You have
Sudden
earlier also,
provocation.
you have earlier also done it, and thereafter again you.
This is the case of the prosecution,
then
and what happened? There is seems there is provocation part. If the allegations are accepted, there provocation part is there And he usually, my lord, intentionally send his cows to the crop.
Therefore you will kill.
Is this
Right
the-
to private defense like this.
No, not right to private defense, my lord.
You
but
made your case
sudden
worse.
provocation, my lord.
You made your case worse by saying that.
If I admit the case of the prosecution, but there is I have, my lord, no eyewitness to
Provocation
the
by sending the cow to the to gaze in the field. This, if that is the provocation, can you kill someone?
no, my lord.
And the countryman, the gun is recovered.
Yes, madam, it was
And
received.
you admit that that was there with you. And you also admit the fact that the same incident happened.
Not
So the
admit, my
motive is
lord.
clear.
My lord, I am not admit. This is the case of the prosecution.
Then what is your case? Why are you telling about prosecution case? What is your case?
Only on the basis of confession of the present petitioner and recovery, my lord.
Earlier
And
meeting was
no
there,
eyewitness there.
Earlier there was village meeting, my lord. And leading to discovery that a gun was seized from the present
This is
petitioner.
my lord.
And my lord, before the occurrence, that the present petitioner also disclosed that I will kill this person. That also one of the 164 and 161 statement
So
of the
read that.
my lord, 164 my lord, I am reading.
Hmm.
That Tapa Patra. ଯେ ମୁଁ ଆମ ଘର ପାଖ ଦାଣ୍ଡରେ ଗାଧୋଉଥିଲି ସେଟାକୁ
Under section 164
KRPC.
KRPC. The complicity of the petitioner is reflecting from those evidences. Therefore, I am not inclined to grant the petitioner, admit the petitioner on case. However, liberty after those material witnesses in custody is more than 1 year to see that all the material witnesses are examined as expeditiously as possible. Expeditiously as possible. The petitioner is given liberty to renew his bail plea after 4 months.
3 months, my lord. Charge already.
After 4 months, if the bail, if the material witnesses could not be examined within that time frame, within that time frame. If such application is if bail application is moved by the trial court, by the petitioner before the trial court, the same shall be considered on the basis of the materials available on record, and then yes.
After 3 months, my lord, a charge has been framed since long, my lord.
32. Yes. 32.
May I please, madam, I am permitted to place on behalf of Mr. Barik, madam.
Yes, it's impossible. No problem.
Petition is in controversy since 1810-23.
1810-23.
23.
Yes.
Allegation 376-2 and 376-3, 506, read with section 6
Yes.
of
Yes.
POCSO Act, madam.
POCSO.
Informant is the father of the victim, madam, was that the present petitioner, who is in relation to the
When-
uncle, Dada of that girl, stayed in their house on his absent.
You are the uncle.
Uncle Samporkiya Dada. Was
You are
staying-
married.
Madam?
You are married.
No, 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 I'm not. I'm not.
You are 26-year-old.
20
Yes.
years old.
164. Read.
And victim is 15 years.
164.
164 is there.
And I'm reading.
Read it.
What happened, my lord, is the victim was pregnancy of 8 months, my lord.
Hmm?
The
Pregnant.
victim was pregnant. 8 months pregnancy was
And
there.
you are the uncle.
And she
Assuring
was
marriage,
there.
allegation is assuring marriage.
No, how 15 years girl
Your
is
uncle, what kind of see, these cases are very hard.
164 statement is stated.
And if they are in relationship, young boys and girls, then one can understand. You are the uncle. If the family member will start doing all these things, 15-year your girl and
All are daily workers, my lord.
whatever. POCSO is not meant for this thing. It's only right on.
Charge sheet has already been
The
submitted.
fact that witness is examined.
Charge sheet has been submitted on
That is submitted on 13/12/23.
This petitioner is accused in so-and-so case. Allegations of the petitioner is so-and-so. The petitioner is stated to be the uncle of the victim girl who is 15 years old. Due to alleged sexual assault by the petitioner, the minor victim girl becomes pregnant on the film. Regarding head to the aforementioned facts, I'm stage of liberty granted to the magistrate to bring him into after the examination of the victim and the informant.
My lord, that both 376A3 is there, my lord. Notice was served to the informant on 5/4/24. That may be.
Notice was served to the informant on 5/4/24, but none appears. ऊपर लिख दो sir. Yes.
33. May I please? 33, 3763 is there.
Oh,
So
164
neither CD
with
nor complaints
minute,
report
huh?
has, neither CD nor complaints report has come. I want
last order, your lordship kindly.
Postal requisites has already been filed by the petitioner.
164 statement
Yes,
with me,
just
my
see-
lord.
1 minute. Let us see the service position.
Last occasion also same statement was stated by the state council, my lord.
If I'll take the last order, then I will dismiss it. Notice was issued, you didn't file the.
No, I have already filed since long, my lord. So
Thereafter,
while, my lord.
I passed the order that the same which was filed lately can be utilized for service. Am I not entitled to see the service report also?
Yes, your lordship kindly see.
What is this? I don't understand.
No, what happened, my lord?
Jumping at the head of the court.
Sorry, my lord.
Please have patience. Otherwise, I will not hear your matters. I'll tell you.
Again, I am sorry, my lord. 376 by 511.
The order is the requisites which was filed to be utilized for the purpose of service. Am I not entitled to even see whether service is completed or not? I am asking service and your.
Last occasion, your lordship stated so, like.
Very unfortunate. Service देखो ये. Huh? See now.
Last occasion, first when it was listed before the lordship, before that, my lord.
List in the October. Service, you complete service. Yes, next.
I am sorry, my lord. Last occasion, your lordship.
Notice was issued, you don't file the requisites.
No, I have filed earlier, my lord. When first time, my lord, notice was
report,
issued.
I should go by the report of the court.
Last, when it listed.
And when I look at it and you shout at the top of your voice.
Mic again high speed.
This has been going on. I observe it. Not that I'm so this thing. I don't react. It doesn't mean that I don't understand. क्या पूछ रहे थे? Sorry.
Late filing notice could not be issued.
Just see. Late filing of requisites, notice could not be issued. Its fault is whose?
I am saying, my lord, when my case was listed, my lord Justice A.K. Mahapatra, my lord, directed notice issued, my lord. Last occasion, your lord, already I have filed at that time, my lord. Thereafter, it has come before your lordship. Last occasion, your lordship directed state to appear through police, my lord, it will be notice to be served and it is utilized by the court.
Yes, that's
by the section.
So that is why I wanted to see what is the position.
Yes,
and now the position is service is not complete.
Short date may be
So
given.
wait, because these are requirement under law.
This is 376 by 511. That's why, my lord.
Whatever, it's a requirement of law, I have to follow it. I can't give bail like this without following the requisite. You file a fresh requisites and notice, await it. Await service. Let us see. The service is awaited. Put it after, leave this week on that week starts from second, please, any day within. Let us see if once the service is complete, I can record that service is complete, nobody appears, then I can proceed.
Let them also, my state council notice be served.
The service on opposite party number 2 is still awaited. The state council is also directed to take steps to see that take steps to serve the opposite party number 2 through the IO of the present case.
He may be directed to survey extra.
I'll serve.
Mr. Sau is directed to serve an additional copy of the bail petition to the state council. Yes, do it.
34.
Yes.
Lordship, item 34, Lordship, kindly pass over, Lordship.
Pass over, okay.
My lord, 34, my lord.
Yes.
Everything is there, but only the statement copy in the case diary, my lord, that was not legible. So otherwise, all things are there.
Not legible at all.
Not legible, my lord. It
Lordship,
cannot-
I
Yeah,
have filed, Lordship.
Huh?
Today itself, I will.
Please give it, put it after 1 week. Yes. Please do it,
My lord, I will-
and replace in the court file also, so
Lordship.
that it will be easier. Yes.
35.
May I please, Lord? Lord, the petition has custody since Lord 3/1/24.
3/1/24,
Lord. And the allegation that on the day of the New Year, the petition along with the others, Lord, they're celebrating the Lord making feast, Lord. And out of Lord the joy, the petitioner fired his from his consummate pistol to the air. And subsequently, my lord, the principal accused, my lord, the Umesh Singh, my lord, was with the.
What is your age?
27
years. Yes.
My lord. My lord, he took away the pistol from this petitioner. Also, he also fired. Then the main accused Umesh Singh's brother came. Like, why you are wasting your time here and not taking care of your parents? Then out of anger, Umesh Singh, my lord, fired to his brother.
Okay. You are not missing.
I'm not fired.
He has only that, my lord, he has kept that unlicensed gun with him.
He was procuring, he had the license, gun with him.
Gone with him.
And
Another
Umesh Singh took it and fired it.
fired his brother. That is the eyewitness, those
That is
who
there.
are in the feast, my lord, they also.
He is
said.
already there.
Charge sheet only submitted against him under section 25-27 Act. 302 is not there.
And that, right now, petitioner is accusing so and so. Allegation against the petitioner. So and so. Have you written allegation somewhere?
Yes, Lord.
Where is that? Para 2.
Yes, sir. Can you count, my lord?
Para 2, because see, these people are taking allegation from the petition itself.
Yes,
I
sir.
can't keep on giving the
I have written paragraph 2, my lord.
Paragraph 2, he will take it. And
Yes,
thereafter I'll correct it. Don't
Yes,
worry.
sir.
See, the charge sheet has been filed in the present case on
One minute.
Charge sheet submitted on 34-24.
34/20.
The rejection order is 26-24.
That's all right. If I don't want to give bail, then I set it.
So you stand on the way.
From the charge sheet, the charge in the against the present petitioner, charge sheet is filed only under section 25,
1B and 27 answer.
oblique 27. In so far as the offense under section 302 is concerned, it is directed against
Umesh Singh.
principal accused Umesh Singh. The petitioner is in custody since 3/1/2020. Regarding had to the fact that the allegation against the petitioner is only regarding possession of the unlicensed
Consummate pistol, my lord.
contribute pistol, and which is being snatched,
Taken away.
which is taken away by the principal accused to
Umesh Singh.
commit the principal crime.
Yes, madam.
Principal crime. I am inclined to enlarge the petitioner on bail. Accordingly, the petitioner is granted bail with conditions. But you have to with some conditions as we
Yes, sir,
both,
yes, sir.
because you are friend with Umesh and you can.
Yes, yes.
Yes.
Obliged.
6.
Yes. Yes, sir.
Comes under section 302
Yes.
and
Custody.
302.
Custody.
Custody since 26/1/2023.
26/1.
26/9/23.
23.
Yes.
Okay. Yes.
Section 302 and section.
How many of you are there?
My lord,
Five.
5 persons, 5 accused persons.
Yes.
Five accused persons. There are all 10 accused persons. There is no eyewitness to the offense, and there is also.
It's a case of double murder.
Yes.
That the charge sheet was submitted under
What are
section 302.
the role of all the 5 must be different?
My lord, all are taken. My lord, the date, but no eyewitness is there.
Hmm.
There is 2 persons, husband, wife. They were killed, my lord. Husband dead body was found inside the room, and the wife dead body was found near the veranda. And my lord, weapon, that
Yes,
bill
it's
hook
not
was
correct.
found from the spot, and other weapons, axe, knife, kati, each was seized from the another co-accused persons. And the PM
Not from these people.
not from
these
the
people.
Yes.
And my lord, PM report, my lord, that there is 6 numbers of injuries, and cause of death is that spinal injuries and its complications.
What is the role of these people?
These people are only, they were standing outside the house.
No, no, madam,
Without any
madam,
action.
madam, I'm reading the statement of the one of the deceased. That the oral dying declaration that a wife who was assaulted by the present petitioners, husband was died and the wife was assaulted. He has narrated something with the in complainant. Then after she was died.
Soon after that, soon after she.
Madam, I'm reading the
Read
statement
that.
of that.
Read that.
ଆଜକୁ କେତେ ବର୍ଷ ତଳେ ଆମ ଗାଁରେ ନାନା ପ୍ରକାର ରୋଗରେ କେତେ ଲୋକ ମରି ଯାଇଛନ୍ତି ସେଇ ଲୋକମାନେ ମାରିବା ଫଳରେ ଆମ ଗାଁରେ କେହି ଜଣେ ଗୁଣିଗାଳି କରି ମରିଛି ବୋଲି ସନ୍ଦେହ କରୁଛି ସେଥିପାଇଁ ଗାଁ ଲୋକେ ମୋର ଜ୍ୱାଇଁ କପିଲେନ୍ଦ୍ର ମଲ୍ଲିକ ଭଉଣୀ ସସ୍ମିତା ମଲ୍ଲିକ ବୋଥ ଡିସିଜ୍ ମାରି ଗୁଣି ଛାଡ଼ ବୋଲି ବେଳେ ବେଳେ ଝଗଡ଼ା କରୁଥିଲେ ମୋର ଜ୍ୱାଇଁ କପିଲେନ୍ଦ୍ର ମଲ୍ଲିକ ଭଉଣୀ ସସ୍ମିତା ମଲ୍ଲିକ ସେମାନେ ଗୁଣି କରୁନାହାନ୍ତି ବୋଲି ପ୍ରମାଣ କରିବେ ବୋଲି କହିଲେ ବି ଗାଁ ଲୋକ ଶୁଣି ନଥିଲେ ଝଗଡ଼ା ଫଳରେ ଜ୍ୱାଇଁ ମୋ ଭଉଣୀକି ଧରୁ ଏଇ ବର୍ଷ ଫେବୃଆରୀ ମାସରେ ଆସି ଅବଡ଼ାରେ ରହିଲା ମେ ମାସରେ ଗାଁ ଲୋକ ମୋ ଜ୍ୱାଇଁ ଭଉଣୀକୁ ସମାଧାନ ହୋଇ ଗାଁରେ ରହିବା ପାଇଁ ଡାକିଲେ ଫଳରେ ମୋ ଜ୍ୱାଇଁ ଓ ଭଉଣୀ ଗାଁକୁ ରହିବା ପାଇଁ ଗଲେ ତାପରେ ଗାଁରେ ଗୋଟେ ମିଟିଂ ହେଲା ସେଇ ମିଟିଂରେ ଅନନ୍ତ ମଲ୍ଲିକ ଦମାଦୁଆ ସମିତି ସବୁ ସମ୍ ପର୍ସନ୍ସ ଉପସ୍ଥିତ ଥିଲେ ସେଇ ମିଟିଂରେ କପିଲେନ୍ଦ୍ର ମଲ୍ଲିକ ଓ ତା ସ୍ତ୍ରୀ ଗୁଣି କରୁଛୁ ବୋଲି କଥା ପଡ଼ିଲା ଜ୍ୱାଇଁ ଓ ଭଉଣୀମାନେ ଗୁଣି କରୁନାହାନ୍ତି ବୋଲି କହିଲେ କିଛି ଦିନ ପରେ ପୁଣି ଆମ ଗାଁ ଓ ସେମିଳି ଗାଁର ଲୋକମାନେ ଗୁଣି କରୁଛ ବୋଲି କହି ସନ୍ଦେହ ଆରମ୍ଭ କଲେ ମୋର ଜ୍ୱାଇଁ କପିଲେନ୍ଦ୍ର ମଲ୍ଲିକ ଓ ଭଉଣୀ ସସିତା ମଲ୍ଲିକକୁ ଜୀବନରେ ମାରି ଶାନ୍ତିରେ ରହିବ ବୋଲି 25/23 ତାରିଖ ସୋମବାର ସନ୍ଧ୍ୟାବେଳେ ଗାଁ ପାଖରେ ଗୋଟେ ଗୁପ୍ତ ମିଟିଂ କଲେ ତାପରେ ସନ୍ଧ୍ୟା ପ୍ରାୟ 7:30 ସମୟରେ ଆମେ ସାହିରେ ଶୁଣିଲୁ ମୋର ଜ୍ୱାଇଁ କପିଲେନ୍ଦ୍ର ମଲ୍ଲିକ ଓ ଭଉଣୀ ସସିତା ମଲ୍ଲିକକୁ ଗୋଡ଼ପଙ୍କା ତଳସାହି ଗାଁର ଲୋକମାନେ ମାରି ଦେଇଛନ୍ତି ଏହା ଶୁଣି ମୁଁ ମୋ ଭାଇ ହରୁ ମଲ୍ଲିକ ଓ ଭଉଣୀ ସରସ୍ୱତୀ ମଲ୍ଲିକ ଓ ସାହିରେ ଅନ୍ୟମାନେ ମିଶି ତଳସାହି ଆଡ଼େ ଗଲୁ ତଳସାହି ପଥର ତଳେ ଭଉଣୀ ସସିତା ହଣା ହୋଇଥିବାରୁ ଚାଲି ପାରୁନଥିଲା ବସି ପଡ଼ିଲା ମାଡ଼ ଦେଖି ଭଉଣୀ ସସିତାକୁ ଆମେ ଟେକି ଆମ ସାହିକୁ ଆଣି ତାର ବାପଘର ବାରଣ୍ଡାରେ ରଖିଲୁ ତାକୁ ମୁଁ ଓ ଅନ୍ୟମାନେ ପଚାରିବାରୁ ସେ କହିଲା କିଛି ସମୟ ପୂର୍ବରୁ ସେ ଓ ତା ସ୍ୱାମୀ ଘରେ ଥିଲେ ସେହି ସମୟରେ ଆମ ଗାଁର ବୁଡୁ ମଲ୍ଲିକ ଚୈତନ୍ୟ ମଲ୍ଲିକ କାମପୁନ ମଲ୍ଲିକ ଦେନ୍ ମାଇଲ 4-5 ଚନ୍ଦନ ମଲ୍ଲିକ ମିଥୁନ ଜଳେନ୍ଦ୍ର ହେମନ୍ତ ସୁବାସ these are petitions
All are there.
No, all of them are not.
ସମସ୍ତେ ମିଶି
Jitendra Malik name is not there.
ଚନ୍ଦନ ମିଥୁନ
Chandan, Mithun,
ଜଳେନ୍ଦ୍ର ଜଳେନ୍ଦ୍ର
Hemanto.
Jolendra is there, Hemant
Yes,
is
yes.
there.
Yes.
One
Subhas
minute,
is
let us
there.
understand.
Yes, yes.
The names are there. There is a dying declaration. I
Yes,
understand.
yes.
মানে চন্দন মিথুন
Not
Chandan, Mithun,
হেমন্ত
Hemanta, yes,
সুবাস
Subhas,
জলেন্দ্র
Jolendra,
all person 5%
Jolendra is there. Yes, yes.
ମିଶି ତାପରେ ଅଲଗା ଅଛନ୍ତି ଅଗଷ୍ଟ ଅଷ୍ଟମଲ୍ଲୀ କୋମଳ ସମସ୍ତେ ମିଶି
Yes.
ହାତରେ ଟାଙ୍ଗିଆ ଖଣ୍ଡା କାତି ଧରି ଘର ଭିତରେ ପଶି ସ୍ୱାମୀକୁ ହାଣି ପକେଇଲେ
Yes, there is a dying declaration. You
Oral
take-
dying
Oral dying.
ଏହା
Whatever.
ଦେଖି ସେ କାହିଁକି ହାଣୁଛ ବୋଲି ପଚାରିଲେ ସେମାନେ
See
ହାରିବା
the
ଆରମ୍ଭ କଲେ, ସେ
condition,
ଦୌଡ଼ି
she died immediately.
Thereafter immediately she died. So whether she was in a condition to give that kind of declaration or not,
Oh, those things.
that is the
should be
part of the evidence. But there is, my submission before your lordship is that there was also a leading to discovery and a extrajudicial confession is there. There the accused have stated that 5 persons are armed with weapons, and these petitions, they were not armed with.
Whether this dying declaration is in conformity with the 32 or not, that will be tested. But there is a dying declaration. There are two models.
Yes, yes.
So then how will you get out of it?
That,
How will you get out of it?
yes, ma'am. My humble submission before your lordship that 3 weapons have been recovered, and the accused who has confessed, one of the accused who has confessed that they have 5 of them are holding weapons, and these persons, they were standing outside the residence of the.
To whom
That
to
is-
believe the co-accused whose statement to be believed or
And
the dying declaration?
apart, it's not a dying declaration, it is a oral dying, it was.
Dying declaration.
Oral dying
No, that-
declaration is not be.
And oral dying declaration also cannot be.
It was not before any independent.
See,
witnesses.
try to understand.
Yes,
Husband was killed
yes, yes.
and she had seen it. Thereafter, she was
She was also
severely
assaulted.
injured.
She
Severely
was
injured.
assaulted and.
Thereafter, she takes the name.
Yes, ma'am. So whether
So
she
it's-
was.
it-
Soon after
it-
she was died.
Soon after she has died.
How
that-
many witnesses are have examined?
3, 4.
The total witnesses are 17 numbers of witnesses are there.
17.
17.
So official witnesses are most of them are official witnesses, but one of the witnesses, he stated that they have previous enmity.
Whatever, that is compounding the case further.
So that's why he is, they have.
Regarding head to the
My lord, may I,
application.
there's the confessional statement and pleading.
The
to this
confession regarding head to the fact that there is a dying declaration made by
This-
one of the deceased out of the two, taking specific name of these petitioners. I am not inclined to admit the petitioners on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the material witnesses are examined. The petitioner is also granted liberty to renew the bail plea after 6 months if the material witnesses could not be examined by that time. Whenever the petition is moved, the same shall be considered on the basis of the material available on record on the time. Yes, next.
37. I plead yours. I'm in virtual mode.
The court, my lord. Under the law,
These are very.
said that time and again she should not be called to the court, my lord. For that reason, they are appearing VC, my lord. Police have to there, my lord, to identify her, my lord.
Doesn't mean she is seated in the police station and.
But when see in the many cases it happens.
No such why, my this honorable court and the apex court, my director, the victim appear through police station because there is no such facility, my lord, to appear, my lord.
So this VC mode is.
That is, my lord.
Function code virtual mode.
But see, the problem is if you start doing all these things, 70 matters you can't deal. Only one matter one day. And the magistrate will also be busy on doing this. This is also a practical difficulty.
Whenever 373 is there, for that reason, notice issue.
I think magistrate will leave everything and start doing all this. Yes.
38.
Alleged offense 376 AB 6 POCSO Act, my lord. The present since custody since 5 April 2024. Meantime, charge sheet has been submitted on 3/6/2024. Present petition, my lord, murder is
You
seriously.
want to do it after lunch, after having lunch.
Interim bail application.
Get some energy thereafter.
No, my lord,
Yes. Custody since
Custody since, my lord, 5 April 2024.
5 April.
In meantime, charge sheet has been submitted on 3/6/2024.
3/6/24.
My lord, interim bail file, my lord, his mother is seriously ill and now is under treatment.
Talk about the main matter. If you are entitled to bail, I'll grant bail. Otherwise, we will see.
The
Interesting.
alleged offense, my lord, is 376 and 6 POCSO.
Maybe 164 you have.
376 AB. 6 POSCO. Victim is a my lord 9 years child.
Oh.
And my lord, there is also medical examination report that is signed. And 164 statement, my lord, I am passing this.
No, don't tell all further. 38-year-old man,
Yes.
9-year-old girl. No question of bail. Simple.
Only reason is that they both are friends. They
What a
went to
friend,
the
9-year-old girl and
No,
you are 38-year-old man.
No, my lord,
What are you
the
talking?
informant, the father of the complainant, so
That is much more difficult. You are the friend of the father of the girl and you are doing all this. No question of bail.
my lord, the mother may be seriously ill, my lord, may kindly consider that interim bail.
If you do like this, what happens? Right on. The petition is accused in where is that rejection? One side. Petitioner is accused in the FIR number 2.
My lord,
He's agreed by the order dated 1/5/2024, whereby his bail plea has been rejected. Subsequent thereto on 3/6/2024, charge sheet has been filed. Regarding head to the seriousness of the allegation, I am not inclined to entertain the bail plea of the petitioner. Hence, the application is rejected. At this stage, petitioner has moved an application for grant of interim bail on the ground that his mother is seriously ill. Since I am not entertaining the main bail plea, it would be appropriate for the petitioner to approach the trial court for interim bail, interim bail, interim bail. Liberty is granted to petitioner to move, renew his interim bail plea before the court below. If such application is moved, the same shall be considered on its merit after verification, after appropriate verification. Appropriate verification. With this observation, the petition is disposed of. Yes, next.
39.
39? Withdraw. Yes.
Yes, my lord, charge sheet file notice is on 395, my lord.
39.
Yes, my lord.
Somebody withdraw.
So,
Withdrawal memo is there.
File, my lord, one withdrawal memo to renew his prayer, can grant
Yes.
some liberty to renew his prayer.
Yes. Land Council for the petitioner seeks to withdraw the petition with the liberty to renew his bail plea for the trial court. Liberty is granted. Yes. Yes. Next. 40. Yes, sir.
The petitioner in custody since 10/5/2024, your lordship. 10/5/2024.
Yes.
Allegation under section 21B of NDPS Act, your lordship.
Recovery?
45 grams, which is less than commercial quantity, your lordship. Already 3 months in custody. And he's the only.
custody.
No, antecedent?
No antecedent. I've avoided, your lordship. In para 7.
Less than how much? Less than commercial quantity you said?
Yes, yes.
How
your
much? How much? 40?
45 grams.
45 grams.
The commercial quantity is more than 250 grams.
You consume for yourself. You kept it for yourself.
That is not.
No, that is a defense. There is always a
The
defense.
consumption is also crime, your lordship.
So what do you say? Less than commercial quantity.
Lordship may impose some
Subject
conditions.
subject to verification. Subject to
One antecedent is there.
antecedent. Huh?
One antecedent is there.
There.
Yes, 392/25/27 Arms Act is there.
No, similar case.
No, similar, there is no other NDPS case.
Verification of similar incident. Recovery is 45 grams of brown sugar.
Yes, sure. Heroin.
Brown sugar, which is less than commercial quantity. The petitioner is in custody from 10/5/2024. Granted bail with the condition that similar antecedent. Verification of similar antecedent. Yes. Next.
41.
41.
First item of the fourth matter, my lord, that is BLPL 5799.
How many matters are there?
3 matters, 5 matters, 2 accused persons.
2 accused person.
My lord, Ramesh Chandra.
How come it is 2 FIR or what?
3 affairs.
Okay.
Your lordship, I never glanced to the BLPL 5799 of 2020.
5799.
No.
Tell me the facts first.
Well, fact, your lordship, I never glanced to page 12.
Tell, just give me idea.
Idea is, my lord, there is in 2015, the informant has alleged that he has given me 10 lakhs to do some business in the kerosene dealership. After that, in 2015, then again after 5 months, he has given 15 lakhs. And in total, he has given me 58 lakhs. In 2015.
That is his allegation.
2015. He has lost the FIR in 2024 after 9 years. That I have frauded.
This is one FIR.
If this is one.
What about the other one?
Other FIR also same light. And one FIR is something different, my lord.
Total how much you have taken? In one FIR 58.
58 lakhs.
And the other one?
Other ones, my lord, that there is I have given some amount. I have given check. There is a 130-day act. So there is a multiple allegation here. What happened in this case, my lord? Your lordship, you can have a glance to. I have, my lord, went to the police.
The custody since?
Custody since, my lord, 24/4/2024.
24/4/2024.
In one case, my lord, the factual background, my lord, I have lodged an.
You have CD with you?
Yes,
ready.
I have lodged an affair. I went to the police station to complain about my tenants, my lord. They are creating some disturbances. Police at the police station police inspector, my lord, threatened me, you give 70,000 for there is a alteration words between the IIC and myself. So I have lodged a complaint. I have approached this honorable court, and as per the honorable court, I have filed an 1 CC case against the IIC, which was registered as page 25, my
Okay.
against that
IIC.
IIC.
Yes.
So for that reason, my lord, he has collected some data against me, my lord, and this planted this petitioner.
But the complainant must be original complaint.
Yes.
He could search the complainant. Successfully search and ask him to file a.
I am not a saint, my lord. I have some antecedent. So he called for some of the petitioner, my lord, informer, and lost the affair. That transaction took place in 2015. In
And
2015.
he utilized the
Yes.
informant to lodge a case. And,
So
took the
five cases, one after another, in a span of 1 month, my lord, he has lost my.
What happened to the complaint case?
Complaint case is pending in 2024, na? My lord, that is pending, my lord.
Now, the FIR was registered after the complaint case or before the complaint?
Before, no, affair was after.
After. All the FIRs.
All the affair.
Yes.
Lordship, there is, he has, this is one, he will give the license of the dealership. And from other persons also, both petitioner Lakshminaran and as well as the.
But all these things had happened in 2015.
2015, 17, 19, all these things happened there
And when the FIR
to
was
give the job, so much
right, but
person he is given.
2024 they are filing FIR, and that FIR is registered only after he started taking action against the
No,
IIC.
before that it is also there. Your Lordship have glanced to
Show
the
me
charge sheet
the dates.
and CDA Lordship.
Show me the dates of the FIR and the complaint case. Where is the complaint case?
My lord, annexure 6, page 26.
Tell me the date of the
My lord,
complaint.
22/3/2024.
22/3/2024. 24. And
My
the FIR?
No,
This
FIR
FIR is May.
My lord, 3/4/2020. April.
No, I am on this application 5799.
Yes.
5799 FIR is registered on
3/4.
4/5/2024.
Yes.
4/5/24. Are you confused?
My lord, that is 292.
No. 5799.
No, that Soro PS case number 292.
The Ramesh Chandra Lordship.
292. Of
398.
No.
5798 is there.
Do one thing. You can't research all the things. You give me a chart. I'll enlarge on page. See, if that is the case, after he started taking action against the IIC, all the FIRs are registered, and all these FIRs.
FIR lodged by the individual, not by the IIC.
That's right. I understand it.
Yes.
But all these things have happened in 2015, 16, 17, and 2024. This is filed. Then whatever he says may be correct. I'll grant bail at least, and they'll face it. You give a chart and tell me. Simple.
After
on that. And put it next week sometime.
Yes, LRC may fix it.
Next week. Next week. Next week will be tough for you. But you prepare a chart.
Yes, my lord,
Date of FIR.
Date
of complaint given by you to the police. Thereafter, 1 CC case when you came to High Court.
Again,
all this thing we will relate it. And we'll see.
Your lordship will only fix the date.
The date is fixed. No, I mean, all the matter date will be fixed. 7th? 7th or 8th?
7th.
6th. Okay. But prepare the chart.
Yes, definitely.
Bail complete. 1, 2 better. Another 5 minutes. 5 minutes.
Next week.
Urgent on request, October. Yes.
43.
Yes, sir.
But notice has been served to the another party, opposite party. He has not appeared. Therefore,
whatever you are saying, can you hear yourself?
Well, the notice has been served to the other party.
He has
Tell
not been
little
appeared.
louder, but.
He has not been appeared.
Okay.
Therefore, my lord, time may be given so that both.
This matter, interim order par earlier.
My lord.
That's the whole difficulty. Once interim order is passed, I'll tell you the dates. What 2023 from January 2024, then February 2024, thereafter March 2024, thereafter April 2024, thereafter May 2024, all adjournments.
Last opportunity may be given.
Only because interim order is there.
Another opportunity may be kindly
No,
given.
I'll vacate the interim order and you put it there. Once
It
you
is not
take the
appearing,
interim order, you
therefore,
can't take why have you taken the interim order?
Last chance may be given.
What is the problem? What is this matter is about? Let us understand.
Well, I am a doctor, my lord.
Huh?
While I am going to my hospital, I am a doctor, professional doctor, my lord. While I am going, I met with an accident. I made the complaint. The charge sheet, I have been accused of another. I have been made an accused in the affair. Basically, I am in complaint. I have given the complaint and I
Yes,
am the
what
complainant.
is this case? Why the interim order? Must be good
only-
case on merit, therefore
Yeah,
interim
because
order.
the notice has served to the complainant for that only.
Now, what is the allegation against him?
Allegation, lordship, that mm,
You have also not prepared, it seems.
no, lordship, I am sorry.
Since you have not prepared, he will take the advantage of interim order.
May I place my?
As you are there, please tell me. Yes.
During this case, my lord, this petitioner is a doctor. While he was going to my lord, to his hospital, on the way he made an accident. The person who has dashed this petitioner, for that reason, this petitioner was injured and he was treated in the hospital. He has lodged a complaint before the police. Police were investigated the matter and made both as accused persons. This petitioner,
including the doctor.
this doctor, and also well, the person who has met it. For that, your lordship has granted interim protection and issued notice that person. And notice was not sufficient.
He has a good case, that is the reason.
Well,
But why are you? I'm ready to entertain the petition. So then you are. Why you
on
argue
that
and
day-
finish it up?
On that day, your lordship was asked that let us say notice go. If you will not appear on that day, my matter settled. My lord, for that reason, the notice was issued on that.
So then why are you not arguing?
No, I'm arguing. Well, I'm ready because this notice was there. I know neither Eddie nor the
Delivered. Despite sufficient notice to opposite party number 2, he has the none appears for opposite party number 2. In the interest of justice, one more opportunity is granted to opposite party number 2. Leave the matter consulted for final disposal. It is made clear that no further adjournment shall be given. You argue it. You have a good case. Why are you on this?
And your lordship have that with me. Your lordship has granted statement.
But he is saying something else, no? Anyway. Huh?
44 is a personal appearance.
Interim order is there, my lord.
Interim order shall continue. 44, there is a personal appearance. I will 1 minute.
And our 48 is also personal. Both the parties have access. In item number 40.
Then she is with a child. I want to make her free.
48.
48. 48, let us to take it. She with a child, unnecessary. 48. Huh?
48, my lord.
Yes.
During this case, my lord, your lordship may kindly tell us the affair, my lord. There is a law between the petitioner and the, my lord, opposite party number 2.
It is 376 only.
My lord.
And charge sheet filed?
Charge sheet has been filed, my lord. And
376 one.
And this petitioner is now got married to that victim, my lord. And they have a blessed with a child, my lord.
Call them.
Call
them. Who is appearing for opposite party number 2? Madam, you are appearing? No problem?
No.
They are married?
Yes, sir.
Yes.
He has also filed the affidavit, my lord.
At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. The allegation against the petitioner is after investigation, charge sheet has been filed on 16/4/2020. Evidence is going on.
No, my lord, only cognizance.
Cognizance is taken.
And subsequently, the court below has taken cognizance of offense under section 376(1) IPC. When the matter stood thus, the parties have
Got married and my lord,
got
they are
married,
blessed with
got married, and they are blessed with a child
Male-
also.
male child.
blessed with a
On
child,
the- on
male
the,
child.
Male child also, on the basis of the aforesaid settlement, the present petitioner has filed the instant case for quashing of the entire proceeding. All this,
If your lordship permits, my lord, item 71 of your 17 of your lordship cost list, my lords. Specifically may to be taken off at 2 p.m. lords. We all are ready, my lords. Your lordship take it in matters, lord. So we get ample time to finish it.
70,
71.
71. What is this?
Or that batch of 5 revision matters, my lord, pertinent that road construction matters, the business matters. Or your lordship may fix it to 2 p.m. on any other, or your lordship take it this morning. So that
Today it may not be possible because
meeting is
I'm traveling for
Okay.
inspections. So lengthy
I
matter I
think
can't.
Mr. Kanun will agree with me, my lords. Any day at 2 p.m.
You please tell the date of your convenience, we will put it. Huh?
Yeah, agreed, my lords.
Huh?
Tuesday, I agree.
And the week commencing from 2nd of September. Any
Yes.
day.
Yes, yes.
Any day.
At 2 minutes.
At
Yes.
2. Next week,
But the hell
fully
is-
packed. Fully packed so that, yes.
Yes, ma'am. My lordship, our third item may be taken up in item 11.
Yes.
Yes, ma'am. That's initiation of the criminal proceeding and also the cognizance order. I'm challenging here because there is, my lord, the petitioner.
What, 3 matters, what are those matters?
One matter, my lordship, this is the matter 2930, the third item. I'm challenging the initiation of the proceeding and also the cognizance order. And the second item, my learned friend has paid for direction to dispose of the matter within a
Once the
future
case arising of
paper.
138 proceeding.
And first matter
Arising out of one check.
One case.
One case.
Check of
5 lakhs, my lord.
5 lakhs.
5 lakhs. And the first item, I have approached the learned court below that in absence of any Bhaklatnama, the advocate has appeared and under the 390 section.
You are the accused.
Yes, Lord. 398 GSCO.
See, you are in a 138 matter on technicality, how many petitions?
No.
filed?
I'm what I'm saying, Lord. The one FIR was filed. That was the no clue and final form was that's closed.
FIR regarding?
Regarding NI Act.
No.
But no NI Act.
On being asked for money, he did not pay. On the contrary, it is that
No,
threatened
regarding
with dire
check.
consequences for which
Regarding
FIR was-
check and the check, he's saying that the check signature of the petitioner, the accused is saying that not matching. That's why.
All these things are different.
No,
So why should I interfere?
No, my lordship, that FIR was closed after
Those
investigation.
things.
When all the 3 cases,
No, show me the complaint, show me the complaint.
Yes,
And-
Lord.
And notice, show me the
Man-
notice.
Yes, Lord.
all the
Case
3 cases,
33,
One minute.
Case 33.
In which petition you have everything?
2930, my lord.
2930.
Yes, Lord.
Show me the complaint.
Complaint petition is 33, my lord.
The case is made out, that's all. You can fight it out there, yes.
33, the complaint petition.
Hmm.
And initial statement is page 35.
Hmm.
And my lordship, cognizance order at page 40.
You forget, now show me the complaint.
Yes, my lord, page 33, my lord.
Yes.
Yes.
What do you want to show?
Yes, my lord. That's, he's saying that a loan has been given to the petitioner.
All these things are.
I'm coming, my lord. How the suppressing the fake and the entire suppression of fake.
Have you issued the check or not?
No, my lord.
You have not issued the check.
No, my lord.
What
happened, my lord?
Where is your reply to the 138 notice?
My first page, my lord, 41, my lord. I am saying.
You show me the notice, see your defense.
Page
Whatever
41,
defense.
my lord. Page 41.
41.
Yes, sir. That's objection I filed there.
Objection, I am not on objection, I am on statutory notice. Have you replied to the statutory notice or not? If you have not replied to the statutory notice under 138, presumption operating against you, whatever defense you have
No,
to
no, no.
face
That
the
the
trial.
fact is, my lord, there is a business transaction between the petitioner and the.
I don't know.
I have paid entire dues, my lord. Entire dues pending against me, I have paid. That's 10 lakhs. That's the statement of accounts.
Where is the statutory notice under 138 NI Act?
That I don't have, because I have filed one case and two cases at the instance of the accused. I have one case that matter of the 2022, it is pending till late. IA for 148.3 and 138, both the matters are pending. So for my case is concerned, it was for non-taking of steps by the London
You are the
JMC.
informant.
I am the complaint, yes, ma'am.
Complaint.
Non-taking of steps by the London JMC Kantamanji for disposal of the complaint case as well as IA.
And if you
That was clear. You also was pleased to issue notice on the plea that in the event of appearance of the other side, possibility of we cannot.
If you want to settle, I will interfere. Otherwise,
Yes.
I will not interfere.
No.
Simple. I can't.
We'll pray
All the
for,
three cases arising out of one
may I
CC
pray
case number
for-
2 of 2022.
May I
And,
pray for, my lordship, I will raise all my contentions before the learned court below
That
and
will
it
If
will
you want to
consider.
settle, I can send you to mediation.
No, no, my lord.
No, but
Yeah,
I
here
have
there is
paid entire
direction.
amount. My lordship,
Three
page
weeks,
49.
Let us go one by one.
Yes,
Let us.
Entire
We can't.
Page 49.
No, my learned friend is saying that he will raise all this point during trial.
I know. Let us.
Yes, my lord.
There are three matters, one after another. We'll
Yes, yes.
First
yes.
matter.
Yes.
First matter, my lord,
You have challenged what?
I've challenged, my lord, I've filed one petition at page 21.
All these ploys are only to delay the proceeding.
No, no, my lordship, why I am saying that there's a petition under Article 398 JSU.
Will you
The
pay the money?
advocate has.
Will you pay the money on installment?
Pardon, my lord?
Will you pay back the money on installment?
No, no, no. I have paid, my lord, entire
Okay. Then,
amount.
no, you don't want.
Entire amount. my lord.
First matter I am dismissing. Okay. First matter I am dismissing.
First matter is something different.
Simply.
my lord. First matter is that the petition that
I am not entertaining you. Tell me the fact. I am not entertaining. 138 matters I will not entertain.
yes, my lord. Then what the last matter, my lordship,
Necessary, these
that
matters are
raised-
pending 2022 this matter happened.
Yes, my lord, yes. But entire thing, my lord, is saying the story in the complaint petition and the objection, there is a different story and suppression of fact. Entire suppression of fact, my lordship can consider and also interfere in the case.
You show me your reply to the statutory notice. I am asking you repeatedly.
Statutory notice, I'll take instruction. in
No, no,
this regard.
instruction, I can't read.
Otherwise, I have I have submitted the objection, my lord. Permit, my lord, grant me, I will raise all the objections there and it will be
Yes.
considered there.
Item, first item and last item. First item and last item. Details. Separate let counsel for the petitioner seeks to withdraw this petition to raise all the points before the trial court at appropriate stage. With this liberty, these petitions are disposed of. Insofar as the middle matter which has been filed by him, Gaurav Kumar Agarwal, that is 2930. You file no. This is Anil Kumar. 5414.
That is filed by the complainant, my lord.
Complaint filed for the and
For-
counsel for the petition seeks to withdraw the petition.
That is for, yes, that is for direction of speedy disposal of the, that was the.
You do whatever you want. Seeks to withdraw this petition, dismiss and withdraw. Yes.
Item 22.
All the three
May I
matters
pray
covered,
that
huh?
one CC case of 2022, other side appeared that
Which one?
no,
22.
item 11, all the three matters,
All
one
three
complaints.
Two
that the-
matters filed by him is.
Yes, one case by the
He has
complainant.
withdrawn, one matter you have also withdrawn.
No, no, both the, all the matter, the learned court in session number, the matter we directed to expedite
No, I don't
2022
know
matter.
what is the stage, I don't know. He has many
He has
applications.
only appeared one after other petition is filing and lingering the case since 2022.
And it is this जो matter this being
Second
a
item,
matter
sir.
arising out of a complaint under 138 NI Act, it is expected that the trial court should do well to see that matter is disposed of as early as possible.
Yes.
Yes.
May I please, my lord?
22.
My lord.
Yes.
22, my lord, custody since, my lord, 23/5/2023. the charge yet not framed. Sorry, trial yet not commenced, my lord. And so for case is concerned, I am not in merit. 37 is a bar, my lord.
When the charge sheet was filed?
Charge sheet was
Sergeant's-
filed.
16/11/23.
16?
The state my lord, trial yet not commenced.
Are you in custody since
23/5/23,
1 year
my lord.
already? Yeah? Recovery is 1?
Recovery.
257 kg.
Yes, my lord.
257.
257.
A material witness?
Independent witness, my lord.
Independent.
Hon'Ble.
Yeah, petition is getting so. And regarding here to the fact that the recovery in the present case is a contraband to the tune of
257 kg.
257 kg. I'm not inclined to admit the petitioner on bail, although the petitioner is in custody since 23/5/2023. Full stop. However, liberty is granted to the petitioner to renew his bail plea before the court below after the independent witnesses are examined in the prison.
After the material witnesses.
Na independent material kit here. Independent ammo by na.
Before that, 10 kg, my lord. 10 kg ganja belongs to you.
What to do? He's
Because
entitled to bail.
Urgent this matter, my lord, because.
Urgent could be. He's entitled to bail.
Yes, yes, madam.
Nobody is coming forward. Yes.
44.
May I please, your lords?
Personal appearance.
My lord, due to some medical emergency, he is not here today, my lord.
Learn counsel for the petitioner 6. There is interim order?
No, my lord.
Personal ground. Urgent. October.
46.
Lordship, on behalf of S.K. Das, I'm praying for an adjournment of 2 weeks.
Mm-hmm.
I'm praying for an adjournment of 2 weeks on behalf of S.K. Das.
Interim order is there? No?
No, Your Lordship.
Urgent. October.
Obliged, Lordship.
October.
47.
May I please, Your Lordship?
Yes, madam.
The petition of Victor Lordship challenging the order of revision passed by the court below. Head of the case is that the petitioner as an informant filed an FIR before the police, and police submitted the charge sheet ignoring 5%. Petition informant filed the FIR against 18%. Police filed charge sheet against 13%, ignore 5%, and ignore some offense. So he filed one complaint, protest petition before the court below to treat it as a complaint case, but that was rejected. As though the protest petition was accepted as per Annexure 3. The case record is posted today on the strength of the protest petition.
What do you want to say?
Only I want to say, let it treated be as a complaint. 18% ର ନା ଦେଇଥିଲା 13% ର ନା ନେଇଛି ଆଉ 5% ର ନା
But see, complaint case they can file.
no, it is different. The similar cases are
Wants to part of it is allowed, part of it is not allowed. That is the thing. 13 is allowed 5.
I submitted one citation of the Supreme Court.
Oh, so forget about citation. You want to file a complaint case? File. Who stops you?
My protest petition is there. What
Order dated 27/1/21.
But it treated as the complaint petition and taken.
You move to that court. Why should you come to the 482 court to tell all these things? You tell that court.
In the meantime, in development.
You let it be an independent complaint and you pleaded your evidence.
That was my prayer. Yes, that was.
That was rejected.
That was rejected.
Show me that rejection order.
27/1/2021.
27/1.
Yes.
So tell me.
Petition is there. I have not annexed. I have begun the prayer person. The prayer person. I have not annexed it.
This is the revision code.
Yes.
Charge sheet has been submitted on
It is in the
29/12/20, Lords.
But independently, you can file a complaint case. Why are you trying to convert it to complaint? You file a independent complaint case. I will record your statement and you go and pursue your remedy under section 200. Who stops you? You wanted to move an application, you treat this protest petition to this, all complication. Why are you doing all these things?
Lordship permitted by submitting by.
Land Council for the petitioner is agreed by the order, impugn order dated 27/1/2021, whereby whereby her application for converting the protest petition to a complaint petition has been turned down. Land Council for the petitioner seeks to withdraw this petition to avail the remedy to file a fresh complaint case under section 200 CRPC. With this liberty, he seeks to withdraw this petition. No order is required to be passed in the present order, present petition. The petition is dismissed as withdrawn with the liberty to the petitioner to resort to the remedy under section 200 CRPC if cause of action.
In the meantime, charge.
Whatever, can you stop an individual to file a complaint case? Let her file and do whatever consequence will follow. What the mistake is, she filed a protest petition and there is no merit in the protest petition. Trial court was not agreeing. So she moved an application, please convert it to a complaint case. That was rejected. So instead of that, she should have independently filed a complaint case. Whatever fate may be, let her file.
Okay.
You go and file. Yes.
49.
Notice was issued to open
Yes.
number 2. But
OP
postal tracking
service,
report
service.
is at flag B.
Service?
Postal tracking
Complete.
report is sufficient.
Service complete. What is this case?
The minor offences.
Huh?
You will also can receive the FIR.
FIR
FIR is my lord,
394.
page starts from page 13.
354. You are seeing quashing?
Yes.
Investigation complete.
Yes.
Charge sheet. Nice. Yes. Tell me.
The two my lord,
See,
major
notice-
gal.
Notice has returned, Lordship, without.
No, service
No,
complete.
tracking, postal tracking report is there at flag B.
Service complete.
Lordship,
Report is service complete.
Postal tracking report at flag B. Item 49.
Where are you looking at?
Notice returned from the OP number 2 in this regard. Postal tracking report. Okay. It is in return, Lordship.
Delivered. This report is. Why are you getting so surprised about it?
Because the other part, opposite party should appear and hear.
Service is complete. If needed, I can accommodate one more date. Service is complete. They may.
Or my lord, kindly request the state council to serve the copy through the police. It will be better.
Despite the service on opposite party number 2, none appears for opposite parties too.
Yes, open
None
number
appears on her behalf. In the interest of justice, urgent to such and such date. In the meantime, the opposite party number 2 shall also be served through IIC. After which police station?
Manchester Police Station, Bhubaneswar.
Manchester Police Station. Please the matter. Okay.
I will serve extra copy on my state.
Mr. Pradhan undertakes to serve extra copy to the state council to facilitate.
In course of day, I am just.
Yes.
Free copy of orders. Free copy.
50.
In these means, my lord.
Huh?
Your lordship take
50.
Yes.
50.
My lord.
Withdraw.
My lord, kindly have a glance to the order. Lordship, your lordship.
Hey, it is who has moved that memo? petitioner?
I have filed.
You are appearing for whom?
Now the judgment has been pronounced during pendency of the case. For that reason, I have come to your lordship.
Judgment is in part.
During pendency of the case,
Hmm.
the stay order was up to 4/7/2024. And it was due to change of assignment, the matter could not be listed. And stay order could not.
You want to withdraw?
My lord, 311 petition, I could not be given a chance to take part.
So in appeal, you can't help it, what to
And
do?
without argument, my lord, that the judgment has been pronounced.
There is a judgment against you. You have to file appeal. In the appeal proceeding, you can do whatever you want to do.
Observation may be made, my lord.
How can I observe like this?
My observation regarding, I could not get a chance.
No, that I can't do it.
And due to non-listing of the case, my lord, the order has been filed. That reason I have been-
I understand it. Understand. This much I'll say, that counsel for the petitioner seeks to withdraw this petition to avail remedy under law. At the appropriate stage, appropriate stage, with this liberty, the petition is disposed. Liberty means in the appeal stage, you can move application. You can tell all these things. Appellate court can hear. I can't nullify the conviction order for whatever reason. And this may be a ground also.
Matter could not be listed. I have made a mention before the Honorable Justice.
What can I do, you tell me? Difficulties everybody knows.
My lord.
And when the matters are listed, many of your brothers are taking adjournment. When the matters are listed. If the matters are not listed, you have a complaint. So the boards are so.
Your lordship specifically fixed the date to 4/7.
Sir, everything is all right, but what possibly, what can I do? You tell me in this situation.
I have also.
Can I set aside the conviction order? Then there is an order, wrong, right, whatever. You have to file an appeal. In the appellate proceeding, you can raise all points and you can move application for additional evidence, whatever. That observation I have given. That observation I have given. Yes.
51.
Same order.
52.
52, my lord. The requisites file already filed, my lord. Your lordship, last occasion, your lordship direct to your requisite filed. Requisite already filed, my lord.
Requisites file.
Appearance are there.
Just filed date. Accepted.
No, requisites this matter is disposed of now. Item
52.
52. 52.
Notice could not be issued. Option number 2 due to the non-filing of the requisite.
You have not filed, you.
Filed, already filed, my lord.
See, the order is 14/5/2024.
Yes.
Issue notice to opposite party number 2.
Yes, my lord.
And what is this para 6 then? When counsel for the petitioner submits that
130.
the court below has issued NBW against the petitioner. Acha, you wanted to appear. You appeared there.
My lord, I am the second counsel. Previous counsel, conducting counsel has given power to me.
Have you appeared pursuant to the order of this court on 14/5/2024?
No. Thereafter, I come to file my power, my lord. After that order.
No, it is a 138 case. NBW was issued. I stated subject to condition that you appear before the court on 20th of May 2024. I am just asking you whether you appeared or not. If you have not appeared, I'll dismiss it. Because it is 138 case, you are accused. NBW is issued, you don't go. I give indulgence to you, thereafter you don't go. You change counsel.
So I will take instruction, some
No,
instruction, just,
take
just,
telephonic instruction
yes,
right
yes,
now.
yes, yes.
No, 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 I will dismiss it.
Yes, yes,
One
only
that-
one passover.
No, password I am giving.
Yes, sir.
I will dismiss it otherwise. You are an accused in a 138 case. I give a indulgence that you will appear.
Yes,
You don't appear, change the counsel.
Just one passover I will.
Yes, password.
53.
And if he has appeared, tell me the date when he has appeared. I record it, then only I will. Yes.
53.
53. Yes, sir. %20% you are supposed to deposit. Execution of NBW was state subject to deposit.
My name has not been mentioned, my lord. I have filed V number.
You are in this matter?
My lord.
You are for whom?
Petitioner, my lord.
Have you deposited 20%?
No, no, my permitted to withdraw the IA, my lord.
Not IA. I will dismiss everything. You
Only dispose of matter.
No, no, no.
Dispose of matter. I have filed IA for extension of time, my lord.
Extension of time for depositing.
Deposit.
Withdraw. Learned counsel for the petitioner seeks to withdraw the IA, and consequence will follow. Whatever.
Okay.
Yes. Dispose of.
54.
May I please, your lordship? Let's say, quashing of the criminal proceeding matrimonial dispute. Annexure 2 is the order of cognizance. Annexure 3 is the matrimonial suit was filed, and the lordship kindly begins to running case 15 only, finding part of the
498 506.
498 406. Case of 2012 in matter settled in 2015 before the Judge Family Court, Keonjhar. He gave an opinion, observation that matter settled on the ground of payment of permanent element of 2 lakh rupees, that is mentioned in running page 15. And that rest of the criminal matter, all things will be set out by the parties. Thereafter, she shown an affidavit that I don't want to further proceed in the criminal case, which is a 498 case, which is now. I have annexure 4.
Notice was issued.
Notice was issued. Thereafter, case asinathila.
Now I have no contact with the
2012 case, 12 ବର୍ଷର case ପଡିଛି.
The matrimonial dispute is already settled.
already filed.
Annexure
They have
3
not
also.
filed compromise.
Affidavit is there, annexure 4, and I'm finding certified copy of the family court order is also.
Petitioner is in this petition seeking quashing of FIR number so and so and consequential proceeding. You are challenging FIR or cognizance?
Cognizance order there.
Challenging order dated or petitioner is challenging the order dated 18/6/2013, whereby cognizance of offence under section so and so has been taken. Nothing has proceeded thereafter.
No, case to city
Stay. And the counsel for the petitioner submits that this dispute is arising out of matrimonial discord, and subsequently the parties had settled their dispute, and consequent to the settlement, they applied for dissolution of their marriage by mutual consent. By mutual consent.
In MAT case number 177 of 2013.
By order dated 20/2015.
Yes.
2015. In MAT case number 177 of 2013. The family court Keonjhar passed a judgment dissolving the marriage between the petitioner and opposite party number 2, and in lieu of the petitioner 2. The petitioner has also paid rupees 2 lakh rupees. 2 lakh
permanent
the permanent element. In the settlement terms, it is also agreed between the parties that the dispute amongst the parties pertaining to the present criminal case shall also be withdrawn. The affidavit, the parties have filed affidavit to that effect.
Only OP number 2.
The
respondent wife.
The OP number 2 had also filed an affidavit baby, huh? Baby.
baby Prajapati.
Affidavit dated 20/1/2018 before the court below, inter alia stating as under page 16 para 2, 3 and 4. Para page 16, para 2, page 16 para annexure 4. ठीक है. Despite notice
already enter appearance.
the after notice was issued to the opposite party number 2, they entered appearance. Mr. Naik, appearing for the opposite party number 2, submits that he is not able to contact his client, and the client is also not taking interest in this matter. It appears the parties have settled the dispute, and the marriage has already been dissolved, and the opposite party number 2 has already taken the permanent alimony. That full stop. That perhaps the reason he is not interested to appear in this court and give instruction to his client. Taking into consideration the aforementioned, I am inclined to entertain this petition. I am inclined to accept the prayer made by the petitioner, and accordingly the FIR number so and so, the cognizance order so and so, and consequential proceeding arising from FIR number so and so request.
Affidavit date টা যে 18 কইলেন 15 সেটা
15 করে দেন
20/1/2015 সেটা
20/1/2015 affidavit.
May pardon me.
Before filing of the case, that affidavit was.
And देखी दो. Yes, first.
May pardon me, Lord. I don't know, 53 may can be taken up, my lord, grant some time for deposit the penalty.
No,
or
I
not.
intended to dismiss it.
Pardon me, Lord.
In 138 matter, you
Hey, you dispose the matter, my lord,
I have given a time, it's all right.
Time may be given, my lord. 1 month time may be given.
No, you withdraw, you ask for withdrawal.
Pardon me, Lord. Over 5.
Very interesting. You said that I'll withdraw, and now you went and got advice and came after the order is passed. 53.
53, my lord. Due to paucity of fund, he unable to.
Paucity of fund, it's all right, but the time was granted up till
30/6/2024. June 30/2024.
And now we are in August.
1 month time, my lord, maybe.
1 month time I will not give. 10 days maximum.
Mobilized.
10 days, right off. By order dated 53 लिखो. जो dismiss कर देते हैं ना withdraw कर. By order dated 17/5/2024, this court had directed the petitioner to deposit 20% of the check amount on or before 30th June 2024. The petitioner has moved the present application seeking extension of time. Regard being had to the contention made in the application, further 15 days time is granted to the petitioner to deposit the 20% of the check amount. In the event the petitioner fails to deposit the check amount on or before 15 days, 15 days means like the date of 15 days, and the no further extension shall be granted, and consequence shall follow.
My lord, pardon, my lord, 52. Item
Yes. Yes, 52.
Maybe.
What had happened? 52?
My lord, that your lordship has asked me whether as per the order dated 14/5/2024, my lord.
Yes.
I have appeared before the court below or not. But that order was passed on 14/5. Copy was received on 25.
25 of
2020.
Sorry, I didn't follow.
Your lordship has directed me to appear before the court below on the next date, that is 25/24.
On 20th of May.
May. It was passed on 14/5. Copy was I have got the certified copy on.
When it was uploaded?
16 I have applied.
You may apply after two years.
No.
When it was uploaded?
The downloaded on 20 mail. The later ହେଇଛି.
Show me. You verify and tell me when it was uploaded in the website. It is a mistake of the court, then you take advantage. But if you have applied for certified copy After the expiry of the date, then
मतलब we
you have to
Still
face
he
it.
has applied.
Huh?
He has applied.
14 दिन
apply on
ଗୋଟେ ଦିନ
Upload
ପରେ
କେବେ ହେଲା?
ପଛପଟେ ଥିବ ଯେ।
ପଛପଟରେ ଲେଖା ଅଛି ତାରିଖ apply. Upload ଟା ତ ଆଗରୁ ହେଇଥିଲା.
Upload, if is uploaded little later, then you have. Take it up. Take it up from here. Huh?
Date of birth.
How will you get the data?
From NIC.
Get it tomorrow. Tomorrow.
tomorrow next week ହବ tomorrow ତ ଛୁଟି ଅଛି।
Oh, next week. If it is uploaded subsequently, then I can enter it. Not on the basis of your certificate copy. It was passed in your presence.
Yes, sir.
You should have gone there.
Without certified copy they
It's
can
not necessary you.
they cannot enter since NBW has issued.
See, I'll tell you, for appearance, you need a certificate copy, permission from the court.
NBW
You said that I am going to appear.
No, no.
NBW was issued. You should have gone and appear.
NBW for that reason my lord certified copy is. Your lordship is right. No certified copy necessary for appearance. But since NBW issue and your
No, our courts are very smart that way. They will see the
no, your lordship
website.
observe that for that reason certified copy is necessary.
Then, huh? देखो देखो. Now you are seeking extension of time.
My lord, we actually brief as transfer to me.
Now council is changed now. This is the tech
that is not the
this
tech.
the what is the check amount?
2 lakhs something. My lord, 205 was
He will not pay 2 lakhs to the person from whom he has taken, but will keep on changing lawyers and spending money 5 lakhs.
এটা
देखो तो. 16th May it was uploaded.
ଆମେ 16/5 ରେ ହିଁ ଆପ୍ଲାଏ କରୁଛୁ।
Then when you got the certificate copy?
420.
Just check. कितने दिन क्यों लगा?
16 and 20.
20.
We applied on 16 and 20.
Timing है क्या?
Timing.
20th you got it. Which court? Which court is this?
Your lordship, sir.
You could have went and appeared. Not that you could not have appeared.
Well, kindly.
Would not have appeared.
Your
20th you
lordship,
got it.
Without the certificate copy, lower court cannot.
21st you could have gone. I have said that if you don't appear, then everything goes.
No.
21st you can appear. Who stops you?
Since NBW has
All these things are faltu. It's a ploy to,
Your lordship.
I'll dismiss it. We'll see later on.
No.
Simply dismiss it without merits. And he will pay now for 2 lakh rupees. Don't worry. Why you are getting embarrassed? Unnecessary, give it back. Yes. Next.
Your lordship, next day, your lordship will dismiss the application. Your lordship, there is a chance of compromise.
Wednesday, you list it on Wednesday. Utilize the certificate copy and Tuesday you appear. Tuesday appear and tell me. Wednesday, we'll see. What is this unnecessary? Wednesday by the coda. I will not say anything. And you know what to do.
Within only 7 days, man.
No.
From today, only 7 days.
Today you are lucky that Saturday, Sunday is there. So therefore, otherwise I would have said that you go and
Saturday,
appear
Sunday,
tomorrow.
Monday also holiday.
Therefore, Tuesday you appear and Wednesday you tell me. Yes.
55.
Keep it on Wednesday. 3 parties matter, right? Yes, sir.
55, that matter. Amount involved is 2,000 rupees. And your lordship referred the parties to the mediation. 468, 471 and 420 case cognizance has been taken on a complaint. Police submitted a final form. And mediation, he also did not agree. That is the report of the mediator.
What is the dispute?
Your lordship, I am appearing on behalf of my senior HM Mahapatra. Actually, he is arguing in another court, so he seeks time.
The mediation, what happened? Mediation?
Mediation report at flag B, your lordship may kindly see. Third paragraph, last two lines. In spite of my best efforts, the opposite party did not agree to settle the dispute amicably through this forum. I am still ready to pay that 2,000 rupees. Here, my lord, it is a civil dispute. My mother and the complainant's mother, they are two sisters out of the 7 sisters, total 7 sisters. The ROR continued in the name of myself even after a civil court decree against me. So the filing relief I received 14,000 some odd, 18,000 some odd. So I paid 2,200 each to all the sisters. And this complainant's mother, she didn't receive and filed the FIR. Police submitted a final report holding that that he has offered, he didn't receive, so it is a mistake of fact. Then a protest petition complaint and cognizance has been taken against me. And I have been offering the amount thrice the draft has invalidated. I have the draft, he is not accepting. Finally, your lordship referred.
What she wants? She wants full amount.
No, he wants a prosecution of myself, nothing else. 2,200 admittedly.
She is your sister only.
More mousy of
This is all ego issue unnecessary.
Yes.
Using the court process to settle your.
And that is apparent on the record itself. I have annexed the documents.
Kindly, I seek time.
I send it to mediation thinking that you are relative and all.
Yes.
I'll quash it now.
I have no instruction. My senior has told me to just take a time.
The mediation report has been received. It appears that due to non-cooperation of the opposite party number 2, the mediation has failed. Counsel for the opposite party number 2 is seeking opposite party is seeking an adjournment. In the interest of justice, adjourn to good 2 week chhadik de diyo and interim order to continue. I tell your senior that I am quashing it. I gave an option to settle the dispute. Your relative and 14,000 rupees is the compensation amount, admittedly. 5 sisters or 2, how many sisters?
7 sisters.
7 sisters.
Including myself.
2,000 rupees he has divided.
All other sisters.
You are entitled to 2,000. Okay, it's all right. If you want entire money, I'll ask him to pay entire money. 14,000 again. To that extent, not that you will send them to jail.
So I'll convey the same to my senior.
I'll tell him to pay the entire 14,000 rupees. If you are so keen to take that entire money.
ସେଥିରୁ ଅନ୍ୟ ସିଷ୍ଟର ମାନେ 5 ଜଣ ଯାକ ନେଇ ଯାଇଛନ୍ତି 2,000 ମୁଁ ମୋର 2 ରଖିଛି ତାଙ୍କ 2ଟା ସେ ନେବେ that is the police report. I have annexed the document.
You are entitled for 2, you take it, another 12,000 give. What to do? I'll tell him I will quash it.
1 minute.
Yes. Interim order to continue, leave it.
That's item 56 and 57.
Technically, he might have committed the crime. But is it not a wastage of court's time? Judicial process you are using to settle your own personal score. And after the investigation, the closure report is filed by police, rightly filed the closure report. Yes.
Interim order to continue.
Interim order will continue. Yes.
Let's say item 56 and 57. I prefer an adjournment. My senior's brother-in-law is admitted in the hospital. Let's say.
Yes, yes, sir. Yes. He's okay.
Admitted today will operation.
He has he had a heart attack or what?
Heart attack. He's in a care hospital.
Yeah.
So.
58.
Last occasion, pursuant to my order, I have submit the proposal for OTS to the bank. Bank has not intimated me. Pursuant to
My lord, I'm not
order of this court, I have submitted the OTS proposal to the bank, my lord. The bank had not intimated me.
No, my lord, may kindly pause. My lord, I'm appearing for the bank. My lord would recollect this is that matter of the truck being taken with 18 lakhs loan and otherwise, and your lordship had asked them to make a fair proposal. Your lordship.
OTS, you have given OTS.
Yes.
Yes,
given
my lord,
OTS proposal.
my lord, may kindly see the documents that they have submitted. My lord, may kindly for a moment.
Now, OTS, have you given OTS
My lord,
proposal?
the OTS is for 2 lakh rupees. For a moment, your lordship may kindly see the statement of accounts. Just for a moment, my lord.
What is the outstanding as of today?
My lord, as on, I'm giving your lordship, your lordship, may just for a moment have it, and everything will be clear, my lord. What is the intention of the party? My lord, the OTS that they have given is for an amount of rupees 2,10,000. Your lordship has that OTS?
What is the outstanding as of today? I'm asking you.
My lord, the outstanding is more than 41 lakhs. My lord, may kindly see page 6 of the statement of accounts. Please. Page 6, the last third line, my lord.
Six up for this one. Six up what?
Yes, yes, my lord. Yes, yes. Eta amaro diya heichi. My lord, memory ame deichu. Tanko OTS or statement of accounts ta.
Yes.
Yes, my lord. May kindly see the last third line, my lord. Page 6, re.
Yes.
41 lakhs is the outstanding on 28th of February 2023. Then we have waived off the interest of 11 lakhs odd. And then we have waived off the check bouncing cases of another 11 lakhs odd. Thereafter, your lordship may kindly see the first page of that.
18 lakh loan. Out of 18 lakh, he has already paid 35 lakh.
That's all right, but you have taken 18 lakhs.
Yes, ma'am.
You might have paid, but by the time you paid it, the interest component is also taken into consideration.
That is a separate thing. I have.
That is the bank. These are
Yes, my lord.
banking
My lord, it is an
challenged the
indirect
cognizance
submission of
order.
my learned friend, my
The
lord.
magistrate
My lord,
has
they have
taken
paid what
cognizance.
amount, your lordship may kindly see page 1 of the SOA.
Section. I have challenged the.
That is a different story altogether. On merit, I'll hear. But last time I said that you give
My lord, please see the statement of accounts first page, my
give a
lord.
reasonable OTS proposal so that they will consider. The books of account shows that 41 lakh. You are giving a OTS of 2 lakh. Which
My
bank
lord,
will accept?
My lord, principal outstanding is more than 10 lakhs rupees.
Principal amount already paid, my lord. 18 lakh they have
My lord, may please see. My lord, that's an
You don't
incorrect
want to
statement.
you want to argue on merits, then I'll hear it and
I'm ready, your lordship.
cognizance order, you know how much limitation I have.
This is a contract loan. This is a contract between the bank and.
That is on merit if you want to ask. I wanted to give you a option. You can you could have given a OTS proposal. They would have considered little bit more. You could have given not 2 lakh rupees. Outstanding is so much.
No, my lord. ଟିକେ ଲୋନ ନେଇଥିଲା ତାଠୁ ଅଧିକା ଦେଇଛି।
କେବେ ଲୋନ ନେଇଥିଲେ ଆପଣ?
18 ଲକ୍ଷ ନେଇଥିଲା।
କେବେ?
2000
लोन केवे नहीं? Which year?
2011 में।
My lord,
2011 you have taken.
accounts.
Today we are in 2024. You don't want to give any
No, my lord. I have in the
interest.
meantime I have paid 35 lakh.
My lord, that is an
35 lakh
incorrect statement, my lord.
86,000.
See, I am not here to go and calculate all these things. It is you sort it out yourself. I will decide on merits. And the cognizance orders are very rare, you know, to be quashed. You think about it.
According to the order of Supreme Court, I am.
That day only I told you, but be careful while giving OTS. Yes.
59.
My lord, may I request your lordship not to extend the interim order? My lord, because now what they're doing is, my lord, what they're doing is they're actually playing and they're abusing the process of law. Because they've got a stay order, my lord. As on date, this is public money. My lord, it all comes down to us only with our taxes being paid.
You have applied file case against civil or DRT against me. In criminal.
My lord,
case,
I am exhausting my remedies under law. My lord, I am exhausting my remedies as a financer under law. My lord, at
But
the end of the
you might have proceeded for recovery.
Yes, ma'am.
You can't employ arm twisting
My
method
lord.
by registering a criminal case and being a bank. Loan he has
No.
taken admittedly. He has
My lord,
paid
that would be a
some
subject
amount.
matter of
Some
trial.
amount is due. You have a remedy under civil law for recovery. You
My
can't,
lord.
being a bank, you can't file a criminal case and arm twist a person and all these things.
No,
Or,
my lord,
it's not.
to just supplement your lordship's argument, fair enough, my lord, an absolutely correct proposal. But whether he had
That
incentive,
is the reason I gave an option.
yes, my
Settle
lord.
it out.
Yes, my lord.
They are also behaving like that. You
Absolutely,
file a
my lord.
civil
Now your
suit
lordship
for
sees the
recovery
intention.
of 50 lakhs, they will settle by paying handsome amount.
My lord, we
Today,
are not asking for that. My lord, even I have
anyway,
instructions from the bank.
I'll hear it after 2 weeks. I'll hear it after 2 weeks. Yes.
Interim order to continue.
Yes.
My
Next.
lord, I have
Next.
strong objections on the interim order, but subject to your lordship's convenience.
You shouldn't forget that you are a bank. Yes.
59.
Banks started, banks also started doing all these things, mischief, like a private financer. Taking loan, if you don't pay, file a criminal case.
My lord, can I
Banks, if the
substantiate?
banks will start doing all these things, what will happen?
My lord, can I substantiate because the lordship has this
What,
opinion?
you can substantiate on technicality this way, that
No,
way.
not on technicality,
Banks,
absolutely.
public sector banks at least should refrain
My lord.
from proceeding against someone in this fashion. You have civil remedies, you have different law, you have debt recovery tribunal, you have surface eye, you have whatnot.
My lord, this
While
is
giving
not
loan,
a-
you should have, while giving loan, you push people, please take, keep on calling day and night. Once you give the what you call the loan, thereafter you are after their life. File a criminal case, pick up the vehicle.
My lord, with the utmost of humility, my lord, subject to your lordship's consideration. Only this one
You are
thing.
holding a problem is you are holding a difficult brief.
My lord, I would argue, my lord, whatever your lordship decides, my lord, we bow down. But your lordship
We'll
knows,
see.
my lord. My lord, the deception at the inception is the question. Can it be decided?
Entry model will continue. In this.
I bow down, your lordship. I can only make a prayer on behalf of my client, but I bow down, your lordship.
Okay. Thank you.
I'm grateful, your lordship.
Yes.
Item 59.
Hmm.
Notice was issued to OP number 2.
They see
Matter
notice,
has been
please.
settled amicably between the parties.
And you are there?
Lordship, I am for the informant. Lordship, fix up a date so that on that day both sides will appear.
You tell me. It is
And next week any date because I have not.
because what is the offense?
306 is my lord. So the X7 case is my lord that 306 cannot be confirmed.
306.
I have a judgment. I have it.
You have it.
Yes, yes, I have a judgment.
Because 306, this was
306.
same, huh? Settle. Let's check it up.
My lord, check it.
Well, see, one thing is 306.
Oh, once,
Huh?
once matter has been settled.
No, the matter is settled. Then you know that this will end up in equator.
Yes.
And
Immediate
judicial
case-
process is misuse, unnecessary burden on the system. You know, he will go and not support the prosecution.
My lord, if in such heinous crime, if the prosecution they will make compromise in all the cases, then it will not permissible my lord, under law.
That's right, you are right. But
That
Gyan Singh judgment says that if there is a blink chance of conviction, you quash it. What to do?
No, that is my lord, I'm different.
That is the reason this court also have given indulgence to matters. You can see through.
My lord, that yes, my lord. That the X7 case I also provided.
Let them appear, but see through. Family dispute, many a time what happens,
Not familiar dispute, my lord. The IIC, he has called the deceased to his quarter, then assaulted. My lord, kindly see the chart.
assaulted and died.
No, assaulted, for that reason he was committed suicide. My lord, kindly see that page, only that page 28, my lord. 28 and 29, my lord. 29, third para. PM report and CDR. Third para is PM report. Fourth para is my lord, that the CDR report. During it, he found that IIC made call to the ASIP Bahali unethically and the sent to his official quarter. Sentry has found it during investigation. My lord, fourth para, my lord.
Yes.
CDR and CF of ex-IIC. The present
29, huh?
29 page.
Yes.
Para
The
4.
Visera reports was sent to.
Para 4, my lord, that is CDR and CF of ex-IIC Samadhan Behra.
No, this is a suicide case.
It's a case of
Suicide,
suicide. He released from custody, he committed suicide in another house.
Out of humiliation, maybe.
If the accused are brought to the police, yes, something is there.
Who is
But
the informant?
My lord, informant is the
Father.
uncle.
What about the father?
20.
Father? Immediate family member? Were they, are they witnesses?
The informant must have been witnesses, my.
Let you bring the father also, because I'll tell you why. The uncle is the informant. We don't know. The uncle might have been sold. The pain is of the father. So let the father come, we'll see. Huh? Put a week for review. Fix. Ask them which is suitable to them. Yes, 60.
Item 60.
60, I am for the petitioner, my lord. I am on.
Make sure that father is there. Huh?
I am in PC, my lord. I am for the petitioner. Only
Yes.
my limited grievance is that 311 petition has been rejected. Well, I am the complainant, my lord. My wife was examined as PW3.
Who is petitioner?
I'm opposite but not two.
You are appealing for him.
Yes, I'm opposite but not two.
1 minute. Let us see who is petitioner. First of all.
He's
I am
petitioner.
I am for the petitioner, my lord. I am with the PC.
Okay.
The 311 petition has been filed by the prosecution to recall the PW3 to exhibit certain medical documents, my lord. That has been rejected. That's why I am filing the petition. On last occasion, your lordship has taken the note of the 301 of CRP, whether the prosecution, except the prosecution, can the complainant file the recall, the petition of the prosecution which has been rejected, my lord. Only
Where is the application?
my lord, application I filed in the IA, along with the IA, my lord. It is a transfer brief. Originally, it has not been annexed. Thereafter, I have annexed in the IA, my lord. Initially, your lordship has allowed, but there are some typographical defect in the accused. In place of complainant, the accused has been typed. Thereafter, I filed a modification of order. And considering this, your lordship has recalled the order and directed to make the accused as a party. For hearing.
You want PW3?
Only my wife who was sustained injury, and out of that injury, my baby under home has died. Certain medical documents.
Why don't you tell me the relevant thing?
My lord, I want to recall PW3 only to examine.
Who is she?
She is the wife, my wife, my complainant's wife, my lord. Was a sustained injury.
After examination of the PW3, 1 year, 9 months, then he's recovered, my lord. And after that,
yes,
I have also made some so cause, my lord.
3/1/24, my lord, can
3/1/24.
Lordship has allowed the petition, but
That para 5, my lord.
The order is shown so by the application. Para
5.
Let the trial court afford one opportunity to the accused petitioner to rejoin. Yes, I have given that. What is the problem?
But that is typographical error. Your lordship, there's some complaint accused has been typed.
Petitioner directed to supply the proposed documents. Thereafter, what happened?
My lord, that is he has to submit.
I have already applied. I have already allowed.
My lord, in this order, your lordship's order, in place of complainant, accused has been filed because I am the complainant. I have approached this court. Accused has not approached. But in the order,
You want a correction of this order?
Yes, I have.
My lord, may I clarify one thing?
For that reason, I have filed a miscase, IA. But considering the IA, your lordship said that as the 311 application has been filed by the state, so have you any? I have the limitation to file recall this 482 under section 301. Your lordship may see the order dated.
My lord, that order maybe your lordship wrongly allowed because of that maybe your lordship produced that the accused person filed the recall petition, my lord.
Let me read and understand. Let me read and understand. I don't need your asking.
I am the complainant, but in order it is accused.
Yes, you are supposed to seek instruction.
Then,
I allowed the application under 311 under the impression that the accused is seeking recall of the witness. Okay? But subsequently, it was discovered that it is not accused who has moved application under 311. In fact, the prosecution has moved an application under 311.
Yes.
And so, therefore, the prosecution cannot be given a second option to cover up the lacunas.
Right.
So, therefore, I have clarified that. And then the legal counsel for the states seeks time for instruction regarding the matter as to whether to insist upon the recalling of the witness or not. In view of the provisions contained under section 301 of CRPC, the matter needs relook. Hence, the order is recalled. The question is, can the state move an application under 311 to recall a particular witness to cover up the lacunas? Because the type of assistance I am getting, the first order was passed. Because whatever these people say, I have to believe, and that impression is given. So I recall that order when I discover it. And you have to seek instruction. That is why the last order, just see the last order.
No,
8/1/2024.
I will be permitted to place that.
8/1
2024. It is the petition filed by the informant. You are the informant.
I'm the
You are the informant.
Your Lordship has wanted to know whether I have the scope to file the petition which has been rejected.
I know that you are for the informant. Yes.
Your last occasion instructed to government to whether if you recover it, objected or not.
I will take instruction. Because no letter was issued in this regard. I will take instruction. Next week I will take instruction.
Informant came to this court.
Yes, ma'am.
Prosecution moved application under 311, which is turned down by the trial court rightly. Then informant came here challenging that order. And impression was given as if the petition, the accused has come.
Yes, ma'am.
I allowed it. I think give one opportunity because he has indefensible right being an accused. But the prosecution doesn't have the right to,
Patch up
fill up the gaps. So therefore, better I should dismiss it.
My lord, I may be permitted, my lord.
Yes.
It is a case covered by Supreme Court in case of Sister Meena Lalita, this is Odisha High Court's decision. When the complainant's petition has been rejected by this honorable court, and Supreme Court has allowed that the criminal court, while adjudicating the criminal procedure, it should be looked into the benefit of the complainant also. Though 301 is the bar, but he can file petition if he is agreed. My lord, this is the case of 307.
I'll tell you, have you moved application under 311? You have not moved application. Prosecution has moved application. And when the application was rejected, prosecution doesn't have any problem. Who are you to challenge it?
That's why I am saying the Supreme Court judgment, my lord.
No, this.
If the complainant, complainant is prejudiced anyway, he can move.
You can move. You can very well move 311, but you can't challenge an order passed in the 311 application moved by the prosecution. You have a right to move. You move. Who stops you? That will be rejected or not. That's a different story. But the judgment which you are showing, that in that judgment, the Supreme Court has said that you can have prosecuted. And if once you move an application under 311, the application is given, copy of the same is given to the prosecutor. Prosecutor has to argue this matter, not that you. You can very well move application.
He just only
But it is otherwise around now.
He just only assists the public.
So you don't have a case. I am recalling it. Right.
And I am ultimately prejudiced, my lord.
You move application. I will give you. I'll just. I'll observe whatever remedy you have. You do it.
Tomorrow the matter was for
I thought I was thinking that the prosecution should have challenged that order. Prosecution is silent. What to do?
Tomorrow the
petitioner is the informant in the FIR number so and so. During the pendency of the trial, the prosecutor The APP, na?
Prosecution.
The prosecutor moved an application under section 311 CRPC seeking recall of the PW PW3. The trial court by order dated 25/7/2023 rejected the application of the prosecution for recalling the PW3 on the ground that the prosecution cannot be allowed to fill up the gap in the prosecution evidence after the lapse of 9 months.
1 year, 9 months.
1 year, 9 months. It is admitted for fact on record that the PW3 was examined by the prosecution and cross-examined on when he was cross-examined.
Cross-examined on 21st October 2022.
31st October 2020. 22. After the lapse of about 1 year, 9 months, the application under 311 was moved. Therefore, the trial court has rightly rejected.
Sorry, my pardon. It is 20 April 21. Sorry, sir. 20th April 21.
20th April 21. Against the order dated 25/7/2023, the prosecution has not approached this court. However, the informant has assailed the said order. When the matter was taken up on taken up on 3/1/2024, this court passed the following order, para 4 of the para 5 of this order. 5 of the order dated 3/1/2024. Okay. Subsequently, it was discovered that the order dated 3/1/2024 was passed by this court under the impression that the petition under section 311 was indeed moved by the accused. Therefore, on 8/1/2024, the order dated 3/1/24 was recalled. The relevant would be to reproduce the order dated 8/1/2024. When the matter is taken up today, the subsequent thereto, on 27/2/2024, notice was issued to opposite party number 2, who is the accused in the present case. So and so appears for the opposite party number 2, and opposes the prayer made by the petitioner, oblique informant. The state so also appeals for the state and submits that he has no instruction regarding the same. Since the state has no grievance regarding the impugn order dated 25/7/2023, whereby the application moved by the prosecution under section 311 CRPC recalling PW3 rejection of the application under 311 CRPC seeking recalling of PW3, the informant cannot assail the same. In view thereof, I am not inclined to entertain this petition. Dismiss. Yes.
The matter was posted tomorrow for argument, my lord. So I may be permitted to giving some times to move the 11th petition.
However, liberty is granted to the petitioner to resort to remedy available to him under law. Yes.
God bless.
Next.
May I please your lordship? In this case, my lord, the petitioners challenge the order of cognizance, my lord, has taken by the Learned James Panpost, my lord,
Yes.
dated 2/6/2022, page 36, my lord, at annexure 3,
Yes.
my lord. The case, my lord, the cognizance taken for offence under section 498A, 406.
Come to the charge sheet. Let us
My
see
lord.
what are they.
Charge sheet was filed on 6/3/3.
Page 33.
My lord.
Come to page.
My lord.
Hmm.
The fact is that on 23/2004, as per order of the Honorable Court SDJM Panpost, Raulkela, in 1cc case number 25 of 2004, filed
What
by-
are the grounds?
My lord, ground is the false grounds because the husband of the complainant was residing at Panpost with her elder brother and doing some business there. She was not interested to stay at the in-laws house. She was initially interested to stay, from the beginning she wanted to stay with her husband at Raulkela, Panpost. Therefore, she after after her husband was gone to her his working place, he is feeling alone and some disputed arose and this case was registered, my lord. She was married to the petitioner.
All these things, where from I'll get?
My lord?
All these things, whatever you are saying, where from I'll get it? These
My
things are your defense.
My lord, I am just stating the brief fact is that
No,
she
facts has to germinate from the record. Whatever you are saying is not visible in the record.
No,
It is otherwise. Let's see the allegations in the
allegation-
page 33. All specific allegations are made.
No,
Wrong, right, whatever.
No specific allegation against any person. One of the co-accused person is dead now, and all others are now the age-old persons, my lord. And now the property, what she is stating in the complaint petition at paragraph, the joint family property regarding page,
Respondent
paragraph
number,
6 at
opposite
page
part number
19, my lord. That is
1
already
minute.
separated.
1 minute service position. I can only do one thing, that once service is complete, I'll see that matter can be settled.
My lord, service was completed last time, my lord.
Let us see.
Sufficient.
Exception? Nobody appears.
Now,
The investigation part is page 34.
34.
My lord. After investigation detail is established soon after the marriage. The complainant in the case lived with.
That's the problem. I 33 also I saw. Yeah, 34 years.
My lord, that is first parameter.
After investigation.
It is established that soon after the marriage, the complainant in the case lived with her in-laws at
Church Lane, Simlipada, my lord.
Simlipada of Hon'Ble
At
town.
Hon'Ble town.
All the affair named accused persons staying together, and Srimati Basanti Lata Deuri and Avanti Deuri, who are the sister-in-law of the complainant, used to stay in their parental house most of the occasion and were interfering in all their domestic affairs. Old and all household articles which the complainant has brought from the parental house during marriage were under the custody of those accused persons. Sisir Kumar Pradhan, the husband of the complainant, used to stay outside most of the time for his work. Taking advantage of the absence of husband Sri Sisir Kumar Pradhan, the complainant Srimati Jharana Pradhan was subjected to torture by those in-laws for more dowry, particularly cash. When the complainant told those in-laws about the incapability of her parents to comply their demand, those in-laws crossed the limit of torture and threatening to do away with her and did not give her food and shelter properly. The complainant tolerated all the torture with a hope of any change in the attitude of her in-laws, but it did not happen. Later, when she felt risks to her life, she left the house of her in-laws at Hon'Ble and went to Raulkela and stayed there in house of another elder brother of her husband, who used to take care of the complainant.
Yes. Yes.
Madam, there are all allegations.
His husband or any the elder brother-in-law.
Madam, cognizance order, how can I quash cognizance order on face of it?
My lord, this is now the paragraph 4 of 6 of the complaint petition, my lord, kindly see.
I can't go into all these things, madam, in cognizance stage. You have to argue all these things at the stage of charge. I will give you that liberty. And I'll give an observation that also that the trial court before proceeding in this matter should make endeavor to see that matter is amicably settled. That much also I can do for you. Beyond that.
My lord, she is not appearing. And also that the joint family property that was in the village, that was already separated, as the long period has been passed, my lord. And
All these
the
things
persons-
can't be considered at the cognizance stage. That's the problem with you.
Kindly be adjourned, my lord.
No, adjournment. After hearing so much adjournment, petitioner is agreed by the order dated 2/6/2024, whereby cognizance petitioners, cognizance for offence under sections. Yes, I'll try to protect you. Cognizance of offence under section so and so is taken against the petitioner. I have perused the charge sheet. Although the allegations are general in nature, but there are separate outtake attributed to the petitioner. Therefore, the order of cognizance. Therefore, I find no fault with the order of cognizance. Therefore, I'm not inclined to interfere in the present matter. However, liberty is granted to the petitioner to raise all these points at the stage of framing of charges, at the stage of before the trial court at the appropriate stage, stage. It is also, since the dispute is arising of matrimonial dispute, the trial court should make all endeavor to see that the matter would be settled through mediation process. With this observation, the petition is disposed. Yes, next. I have given the liberty to argue all this point. Along with that, I said that before the trial court proceeds, trial court should see that it should be sent to mediation and settle the dispute.
My lord, they all are in-laws. Now they are senior citizens. They will already arrested and granted bail, my lord. They suffered a lot. Now this time the property.
I will further give you a little bit more relief in the sense. I'll just write it down. 61, na? This is 61. Write down. To allay the apprehension of the petitioner that the senior petitioner that the parent-in-law, parent-in-law for the
They all are
informant,
in-laws,
those who are senior citizens, shall be insisted to appear before the court on every day proceeding. I further give liberty to the petitioner to move application under section 205 CRPC for exemption from personal appearance. If such application is moved, the same shall be considered, keeping sympathetically, owing to the age and ailment of the parent. Generally, I don't give, but a parent, senior citizens and all. Therefore, that 205 also you can move. What else I can give you? Tell me.
Out of 6.
In a cognizance order, I have given everything. Because it's matrimonial dispute. She is not appearing. So I have taken into consideration. I know it's very hard case what to do, but technically I can't pass it.
And after the mother-in-law's death, the property already been partitioned separately. They are staying in the same property.
That's the whole difficulty in this kind of dispute. Anyway, you see.
Make the lordship.
Here.
No, the opposite party probably is not appearing, or didn't on the last occasion they are not appearing. No, this is a case with the.
They are scared of you, it seems.
That's, no, my lords, this is the case where the chairman of Orissa Power Generation Corporation was made an accused pursuant to a complaint filed by a person who was a nobody in the present incident. What had happened was the occupancy had a ash pond. One of the ash ponds, there was a breakdown. So slurry went in. So there was an agitation. Ultimately, the district administration and the office of the district culminated. Everyone sat down. A compensation of 54 lakhs was paid. So no one's pursuing this. The present opposite party claims to be a president of an NGO and has filed a complaint seeking that a FIR be registered against the chairman of OPDC on the ground that these incidents have taken place and there is a claim for 50 lakhs.
You are the chairman.
Yes,
Managing director. I'm the managing.
OPDC,
I'm the managing director.
Managing MD of.
I'm sorry, I said chairman. My apologies.
Nice.
And most importantly,
And this complainant is a
claims to be the
NGO guy.
Yes, madam. President of one Anchalik Paribesh Suraksha Sangha, my lords. And my lords, most important, kindly see page 25 of the complaint. The company has not been arraigned as an accused, and the officer has been arraigned as an accused. On page 25 of the.
Yes, what do you say?
My lord, two FIRs were lost.
Yes,
One was
two
by
FIRs.
against the unknown person, first FIR, that is on 10/12/23.
Yes, ma'am.
The same guy, same person has filed.
No.
By the villagers,
Another
they have
person.
no claim.
Hmm.
They have all the money has been paid pursuant to a meeting held under the aegis of the.
They took the money and
Yes.
they settled the.
Yes, madam.
And second FIR was lodged
By
on
this-
9/1/24
That is
against the
after-
present petitioner.
that is
And in
much
both
after
the
everything
cases,
has culminated.
and in both the cases, investigation is going.
Going on.
Yes, ma'am.
Going on.
First one is 10/12/23 and second
On
FIR is
what
9/1.
investigation going on, my lords? Lords will kindly see 9/10, 9/12/23 the event took place, my lords, and most importantly, accused has been made an accused. The company is not an other than accused, my lords.
No, that's right, but investigation is still going on.
But in law, my lords, starting from Rita Hada till Salasangi and so, my lords, without making the company as an accused, the officers cannot be made an accused, my lords.
But don't make them wiser. Investigation is going on, they will make you an accused.
Lords will kindly see.
Who can stop them?
It's a
If that is the only objection,
No,
but in
no.
charge sheet they let you
No,
at the
That's-
company.
yes.
Kindly see. May I just take the lordship dates? Incident takes
But
place
anyway,
on-
you are in the meantime proceeding in FIR number so and so. What is state then?
But in the meantime, the proceedings in FIR number so and so, data registered before the Banharpali police station arising out of 1cc case number so and so, shall remain state in the state. How can the investigation? Making a statement, but I will not say anything more. Minutes. It's right in the teeth of the order. But I will not say anything more. I will not say anything. I think
No, but
he
that's
just
what-
made a statement. But I will, after all, he's all lawyer. I will not say anything more.
What to
Right in the
say?
teeth of it.
My lord, what I couldn't understand what he says. There
No,
which-
no. See, the interim order is virtually staying the investigation.
No, that order is not with me.
Made of cake man, my lord. That's all I'll say. Because it's a
Because
case
was
of
the
cake-
record shows that, my lord, that the investigation in the first case, the
Is it arising out of 156.3?
Yes, my lord.
second one is on 156.3.
So then
First
this
one-
interim order has to be varied. Otherwise, you can't file charge sheet.
But in the first case, my lord, the investigation is also going on. Two cases are there, my lord. One by the villagers on the banner of Bharatiya Janata Party.
The FIR was also the complaint.
It is against unknown person.
So-called president of Bharatiya Janata Party, not even that villagers. The affected party have not pursued any.
Why don't you complete your charge sheet?
Affected parties
investigation?
have not filed any kind of case anywhere.
See, maybe because of this order dated 8/2/2024.
I would kindly see for. I would kindly see. Kindly say page 31 annexure 3 minutes. Page 31 annexure 3 minutes. If I may be clear.
No, where is that complaint on
Sorry,
153?
that is page 25.
Hmm?
Page 25.
25.
Again,
Yes.
page 25.
Next year?
Minutes, it's a continuation minutes.
That is
Page 25, it starts 160 case number 251 23 minutes. Sorry, minutes.
Show me. 25.
Again, page 25 again.
1 minute. This is 156.3.
Again.
this is
That-
156.3.
Again.
And page, my lord, 18, that was first affair.
No, I'll tell you. See why the stay was granted. There is a reason. Because of the judgment, there is no supporting affidavit. That's the reason I have stayed.
Affidavit.
But come to page 29.
Yes, ma'am.
Page 29. There is an affidavit.
Yes, ma'am, there is an affidavit. I had made a statement on that. Lordship, there must be a specific affidavit in a different format.
Right.
That is why Lordship gives. Everyone was present there.
Right.
And therefore the affidavit has to be.
Generally, but here the type of pleading, what happens.
Therefore, Lordship had.
Kind of affidavits are being filed here.
And therefore Lordship had.
This is not the affidavit in
Yes,
true
ma'am,
sense.
that is why Lordship had passed the order. I was not going there now,
But let them, you are protected.
yes, ma'am, I am protected to an extent.
Show me.
The only case point that Lordship would call it then fourth and fifth.
No. What I'll see, because of the interim order which I passed,
Yes, ma'am.
that may be the reason they are not able to proceed further.
Question is whether they can proceed in law after all the sequence of judgments, in addition to affidavit, I'm not going on the affidavit, on the sequence of law laid down by the Supreme Court, including our own High Court, that unless the company is arrested, the other proceedings cannot continue.
If this is 156.3, they can, after investigation, they can implement. Then
That I will not question.
today, how do you know that that ground may not be?
It is regarding a Ashburn, who personal allegations could have been made against an officer who has.
I know, but see,
personal allegations
this is
can never be made.
this
An
is
affair and story is being made out in an affair that he was involved in everything. How can the person be involved in the breakage of an Ashburn? And the.
you tell me one thing. In 156.3, suppose one accuse is made in 156.3 complaint, and court sends it for registration of FIR. Is it precluded? The police can't make additional. So then, see, that's the situation here. In 156.3, only Manas Ranjan Raut was made accused. And the court, after examining the what you call the complaint, has referred it to the police now. FIR is registered. Police can add
Yes, ma'am.
any accused. Police can also remove this Manas.
Yes. I know.
Police can also remove this Manas.
Actually, correct. Even I bow down to that. I also bow down. Two affairs on sales and facts.
Then-
Multiple affairs. I bow down to that. The multiple affairs on the sales and facts.
Are you
And
protected
the
or not?
complaint would
You
change.
simply say, are you protected or not? Fully protected. You should not be arrested, that's all. That protection you are entitled.
Yes, my lord. I am protected because it says that proceedings shall not continue before the court below point number 5.
No, that I'll alter now.
May only pray lordship call it on 4th or 5th.
No, what I'm saying is, for the benefit of both the sides, I'll simply say that the state council is saying that the investigation is going on. It will be concluded as quick as possible. And the interim order which I passed shall not stand in the way for continuing the investigation. This much I'll say. I'll not say anything else. Right now. Learned counsel for the state submits that the investigation in the present both the cases are still going on. And he seeks an adjournment on the adjournment to obtain instruction regarding the status of the investigation.
Right.
It is expected that the police completes the investigation by next date of hearing. And next date of hearing, the interim order dated 8/2/2024 passed by this court shall not stand in the way and for continuance of investigation and file the report under section 173(8) CRPC by next date of hearing. You are protected already. If you have any problem, you can come and mention.
Lord should keep it to 4th or 5th.
You list it.
That's fine.
No, 7, 9. And just check it up. Six.
6. Sorry. Sure. I get it.
6. Okay.
63.
Fine.
May I please, Your Lordship?
Yes.
See, last occasion, the matter was sent to the mediation center, Your Lordship.
The DB case.
My Lord.
What happened?
Mediation failed, my lord.
You don't want to settle.
May I pray one thing, your lordship? Lordship, I pray short adjournment, let the matter come.
Okay, adjourn it for mediation, mediation report dated 6/7/2024 is placed on record. It appears that the mediation has become unsuccessful. The parties are unsuccessful. Please the matter for hearing. October. Yes.
64.
My pleasure, Lordship. But I filed a IA today,
Hmm.
IA number 227524, my lord. That can be taken up along with the CLMC.
22?
Because 2275 of 24, my lord.
2275/24.
My lord,
Where is that? 2275.
my lord, third or fourth may be taken up.
2275 is there. No, it's not there. What is that I?
No, the IA is, my lord, for the stay of execution proceeding. The notice I have in the meantime, during pendency of this case, and then this matter was sent to the
What
mediation.
is this conversion? Conversion has already taken place. Achha. You are
No,
telling.
my lord, I have to file that IA today. That has not come today, my lord. It is not tagged today.
No. First of all, tell me what is you are challenging what? You have filed a CRLMC.
CLMC, my lord.
Under 482, challenging what?
The order of interim maintenance, my lord. Under section 125 CRPC.
So then 482, you can't do it. Therefore, there is objection.
My lord.
You cure that objection. IA?
281.
The IA 281. For the reasons stated in the application, IA number 281, application, the same is allowed. The nomenclature of the present petition may be adequately done by it is accordingly directed. There is the to do the nomenclature and leave the matter for hearing. It will go before some other bench.
My lord. And the IA also today filed, that will become tagged today.
First, once it is nomenclature is changed, it will go to appropriate bench.
Then, my lord, your lordship may say before 5th, because the proceeding may be initiated in the meantime.
Release the matter before the
Before
appropriate bench, assigned bench, subject to the approval of honorable chief justice. Yes.
And interim shall be continued, my lord. Interim shall be continued. There is a stage.
I can't say anything because I don't have that jurisdiction.
My
You
lord.
file 482.
My lord.
I pass some order. You move an application, change it to CRLMP.
I am voting this happen.
No. How can you withdraw? Maintenance, you have to file. You file a wrong proceeding and taken. I have to vacate that basically.
In the meantime, what happened, my lord, that you are also directed to mediation, and the mediation also I participated in the mediation.
Whatever, you should not have filed this proceeding in the first day. Yes, next.
65. My lord, I have to say something. Well, I am the wife. So the husband is not complying the order of the interim order passed by this honorable source of family court. Yes, in the meantime, 1 year has been passed. Not single pie has been given by the.
In 64 items he is mentioning. 64 items he is there for husband, my lord.
You are referring.
I am for the petition, my lord. Petition husband, my lord.
My lord, I am for the wife.
64 is over already.
64, I am 64.
64 is over. Yes.
65.
65.
Lord, sir, today we have filed the objection affidavit on the behalf of the opposite party number 2.
Opposite party number 2 has filed is entering appearance and undertakes to file the objection by tomorrow. You file it in the registry by tomorrow. Advance copy of the same is Learned counsel for the opposite party number 2 submits that he has filed the objection, reply objection. Advance copy is supplied to learned counsel for the state as well as counsel for the petitioner. Lease the matter for hearing.
Interim order dated
Interim order to continue.
Mr. The name of Mr. Senior Advocate. Mr. Name of Mr. Senior Advocate may be reflected.
Reflected. Suppose next time you will engage some other senior?
No, he will.
No,
He is there.
you never know. Your client will say that no, I need someone else.
No, he is
Then
there. He is connected. He is
actually, the
online.
name of a senior counsel should not be reflected in the cause date. Once you become add-on as a senior, your name should not come in the cause list at all. And you keep on changing every date of hearing, you keep on changing a senior counsel, and all the senior counsel name has to come. What is this? You are the advocate in record, your name will be there. You
Yes,
can
yes,
engage
my
any
name
senior.
is there.
There. Why senior counsel's name?
66.
Senior counsel name in cause list. What surprising?
No, not in cause list. Ordered appearance of today.
Today.
Today's
Where is senior counsel? I can't see.
Mr. Mishra is connected.
I can't see.
Mr. Mishra is connected through that is the.
I have to see him.
That,
He is not appearing.
that is.
What is this? Yes.
66.
My lord, I am repented on behalf of the petitioners, who is the husband and mother-in-law of the opponent number 2. And I have complied the order who has been passed by this court earlier date. And
Opposite party.
all the records has been submitted before the court for issue notice to the.
I am appearing on behalf of open number 2. Also may grant 2x time to file objection in this case.
Learned counsel so and so enter appearance for opposite party number 2. Since 1 week time to file counter affidavit, lease the matter. Yes.
Wakalatana.
File the Wakalatana. Let him file. Time is there. Yes. File. Along with your reply, you file it. Yes.
67.
Yes.
67, my lord. Notice was issued to open number 2, my lord. Nobody has appeared.
See service. 67. Sufficient.
Out in the appearance, my lord. Somebody may appear, my lord.
Everything service on the opposite party number 2 is complete, but none appears on his behalf in the interest of justice. Yes.
68. Mention your 69.
May I please, your lordship, my lord? My lord, this is an application 311 was filed. The same was rejected. Against that, I have come up with your lordship.
311.
Yes, my lord. But there are 2 points against me. One, that statute itself speaks POCSO. And number 2, my lord, here for substantial justice, I have come up. And what I found, here the love affairs between the girls subsequently turned into this 376 case, POCSO case, my lord. Now, the things have changed. Now, they may get married because the boy is 35, the girl is actually 20. But she has mentioned 14 obvious POCSO acted there. It will be decided during the trial whether she was minor or she was major at that point of time. And we have taken specific pleas because we wanted to re-examine 3 witnesses.
He has already deposed against you.
That is there. That part is there. Depose means my lord does. Only first part when if she was examined, at that point of time, the counsel for the defense was not present. The examination was closed. Subsequently, she was examined. Only 3 questions were put to her. Thereafter, we made these are the questions because the point is here when she is saying that she is minor and we are saying she is major, that has to be come out, my lord. That questionnaires have been framed. Learned court will allowed against PW 11 and 12 those parts, re-examination could only could be allowed. But
those things you can bring through parents also.
Parents, my lord, both lot of questions are there, my lord, because see the Kothakali Calcutta incident hichi ki Odisha hichi incident that part that no part no and that is my lord substantial justice. There is no bar, absolutely bar.
No, there is no absolute bar.
But the party can be given good substantial justice. It is not that we are. I can understand, my lord. Again, if the person has already been examined, and I will put the question without putting any question. I'm making the questions. These are the questions I'll put. It's not that suddenly I'll ask certain question. I have framed the questions. I should be given because I am an accused there.
Come to page 27. Let us see the questions.
Yes, my lord.
Just see.
I'm appearing for the informant.
What do you say?
Lord, the matter has been settled between us. And 311.
See, because she is appearing for the.
My lord.
This is.
I know because this is what
And
developing.
the
Because when the
mother-
matter was come up for the first time, this is. I'm sorry. Joint affidavit have been filed.
Joint affidavit has been filed and
Here,
the mother
here,
of the victim. My
here.
lord. Yes, yes, my lord.
But she is now major.
Well,
She is willing to marry.
Lord, that settlement is going on.
Filed here.
Yes, the joint affidavit dated
Joint affidavit
28,
is there.
28/24.
Last time ko to kori bole. Ye to kar deij. Either this one.
Mr. Das, just check it up.
Yes, ma'am.
And if settlement is they already been made, then call them. She is major. She has already.
Here I have come up. Entire proceeding will be first. I will file that. Yes, my lord. That will do, my lord. Both the parties will
Shall I
agree.
allow it? 311. You go and sort it out.
My lord.
Yes, ma'am. That will also do. Also.
I'll allow it.
Yes, ma'am.
Right on.
Yes.
Petitioner is agreed by, since there is no absolute bar, I can doubt. Agreed by the order dated 3/1.
25 for 2024.
25 or 5/4?
5/4, my lord.
5/4/24.
5/4/20.
5/4/24. Whereby the application of the petitioner under section 311 CRPC for recalling, prior to recall PW5 and PW5, 11 and 12.
Yes, ma'am.
All.
Yes.
PW5 is the victim. my lord.
Victim and
33
11 and 12 are there.
Section
11, 12, that has been allowed. To that,
33
we have no objection.
They have allowed.
They have
My
allowed.
PW5.
Section 33 subclause
That is
5.
there.
I know that,
That
but
is-
now see the situation. She is coming. She says, no, I have no problem. Joint affidavit filed.
Yes. Before commissions.
Right on. Recalling PW5 has been turned down. However, insofar as the PW11 and 12 is concerned, the recall for the said witnesses have been allowed. When this present petition is notice was issued to opposite party number 2, so and so appears for opposite party number 2 and submits that they have settled their dispute. Before this court, a joint affidavit has been filed. Joint affidavit dated
20th August
20.
2020.
20th August 2024 has been filed. Inter alia stating as under. For the vote. Para 8. Para 8 and 9. 7, 8, 9. 7, 8, 9. Then counsel appearing for the opposite party number 2 has no objection if the petition, no objection to the present petition, no objection to the present petition. Mr. Ragala, however, Mr. Ragala, when the counsel will take submits that in view of the bar contained under section 33 clause 5 of POCSO Act, the present applications ought not to have been allowed. Mr. Shogat Das, then counsel for the petitioner, however, states that the said statutory bar is not an absolute in nature. In facts of the present case, the bar under section 33 5 shall not operate against his claim. regarding head to the particular facts of the present case and the fact that the parties have settled that the student filed to joint appeal. I'm inclined to allow this fiducie. Accordingly, the order date is shown so certified, and a singular opportunity is afforded to the petitioner to re-examine the re-examine PW5, no? PW5 on a date to be fixed by the trial court.
I'll oblige, my lord. Husband comes. Yes, ma'am.
Her appearance, I have. She has no objection, therefore I may allow.
No.
Yes.
70.
Huh? No, sir, decide goes.
Yes, 70.
Please, your lordship.
Yes, sir.
Your lordship admits, my lords.
How much time will you take?
It will not take much time.
Ah.
If your lordship, I'll place the charge sheet, your lordship will be convinced that there is no case.
Let it be at least a message or option can dispatch. First case.
Whatever second one.
Second one. Lordship take out the first case so that may throw some light.
No, same FIR, two accused.
Same FIR, there
Same
were a
FIR,
number
two
of
accused,
accounts.
Charge framed, huh? Yes, sir. Can you accommodate one day?
Small matter.
Hey, both the matters, once I hear, if the similar matter at a time we will do it. Next, if it is required for the time, then I'll adjourn that matter. One matter I am hearing, both the matters should be ideally. Just see. We will just see the board, adjust. Otherwise, there is no point of making you people wait till the end of the.
Only one prayer, your lordship may adjourn, grant the interim orders may be allowed.
Interim order will cut.
3 तारीख रख दो ना स्पेसिफिक.
Next, 3rd. See, what is happening is this the regular bail application.
I understand.
You have to hear it. It's fresh bail application, you issue notice and call for CD and all. Within half an hour, things will be over. That's the whole difficulty. Board is not moving.
71 4.
ଦେଖନ୍ତୁ ଆପଣ ଠିକ ଅଛି 5th, but get ready and see, today it may not be possible, but even if it is 4 o'clock, let us, otherwise see, any day you will be like this only.
So what
The
I
board
am
will be like
suggesting is,
yes,
instead of 2 o'clock, we can keep it at 3 o'clock. So
that is better. Instead of waiting, let it be 3 o'clock.
3 o'clock.
At least you can
on
finish
the
up the work and come and sit.
3 o'clock on the 5th.
3 o'clock on 5th. Huh? Yes.
72.
Interim orders may continue.
Interim order.
72 रे interim order to continue. Same.
Same, 72. 71.
71 or 72 same.
7 already attended.
Thank you.
73 tare.
73.
71. 71. 72.
72 tare.
71.
71 is a batch of matters.
71 is a batch of matters in that. 72 tare, I am also appearing.
No, 71, what to do? Oh, that's a different story. Yes. 72.
72 as to say second, first week of September.
So
73 matter same.
Mr. Dharanidhar Naik is
ସେଇଟା ତ ଆଜ୍ଞା
heart attack.
ଟିକେ ଲମ୍ବା.
ତାକୁ ଟିକେ ଲମ୍ବା ଦେଇଦିଅ time. Like he has to recover, na?
Yes.
At least.
Yes, a pacemaker was installed probably today.
So
So
give
he
it in
needs
October.
some time.
October. 73 October.
Yes.
Yeah, unfortunately. this-
72 টা ভাঙে সারা
ରଖ ଆଉ ଗୋଟେ କେବେ ନାଇଁ ସେପ୍ଟ ହଁ 9-10 ରେ ରଖ।